her. So Mr. Poptanich is driving and conduct on that occasion placed Mr. Moore in danger of being injured or seriously injured.
Okay. Is that correct, Mr. Poptanich?
Correct.
And Mr. Beckwith, any additions or corrections?
No, Your Honor.
And Mr. Beckwith, all victims' rights have been complied with?
Yes, Your Honor.
Okay. The court finds that the defendant's plea is knowingly, intelligently, and voluntarily made. There is a factual basis for it. The court accepts the plea and enters it of record. The court defers acceptance of the terms of the plea agreement until sentencing. Counsel, I'm looking at February 2nd for sentencing. Probation 4 weeks should be sufficient. 4 weeks for a pre-sentence report. Mr. DeBrigida, February 2nd at 11:15.
That should be okay, Judge.
And Mr. Beckwith, any issue with that?
No, Your Honor.
So, sir, I'm going to set your next hearing February 2nd at 11:15 here in this courtroom. Before you leave today, either Ms. Mansour or Ms. Leonard is going to give you a packet, and you'd like him to fill that out before he leaves today?
Yes, sir.
So you'll need to fill that out and return that to them before you leave today. Mr. DeBrigida will be around, so if you have any questions on what something means, you can always talk to him. If you fail to appear for sentencing, any guarantees in the plea agreement, such as probation, go away, so make sure you're present. Given that there is a stipulated at least 60-day initial jail term, make sure you have your affairs in order so you'll be prepared to be taken into custody that day. I don't think there's anything in the plea that would prevent work release. If I don't know what your status is, where you're residing, but if you're going to explore that, you'll need to get all that lined up ahead of time. Okay.
And Judge, I'm happy to work with Ms. Mansour about the exact manner in which the jail has to be served. I know that DUI mandatory minimum provisions can be quite confusing in terms of multiple offenses, or I should say subsequent offenses, and what percentage of the actual jail has to be served and that kind of thing. So I'm happy to work with you on that.
Okay. That'll be all then. Thank you, sir. Make sure you get that.
Thank you.
Thank you, Mr. Bishop.
11, and counsel, I'm not sure I said what time. That's 11:15. Okay, and then I have someone on the line with first name Lou. Can you unmute your microphone? Tell me your last name, sir.
Shepard.
Okay, thank you. And let's see here. Okay, Mr. Crawshaw, are we ready on Mr. Kalalongo's matter? Okay. Right. Next matter is State versus Kalalongo, CR 2025-498. I'll note that Mr. Kalalongo is joining us remotely. The court had previously authorized that. Mr. Crawshaw, his attorney, is remote. We have Mr. Beckwith here from the county attorney's office. We're here for a trial setting, possible change of plea. Mr. Crawshaw, can you give me an update on this matter? Okay. Okay. How about, let's maybe even take a step a couple weeks before that, April 15th. Would that work for you, Mr. Crawshaw? And Mr. Beckwith, while he's looking at that, 2 days, 8 jurors, or 3 days? What do you anticipate?
I think 3, just to be safe.
Okay. Okay. And Mr. Crawshaw, April 15th, does that work for you? Okay, and Mr. Beckwith, any issue with April 15th?
No, Your Honor.
So, Madam Clerk, I'll set this for jury trial here in Payson. April 15th, we'll begin selection at 9. I'll meet with counsel at 8:30. That'll be 3 days and 8 jurors. I'm going to set, so Mr. Colongo, I'm going to set actually 4 dates for you. So I've set that jury trial. If you fail to appear for the jury trial can go forward in your absence. Do you understand that, sir? Okay, and then I'm also going to set a final pretrial conference, and we just take a look as we go back. 15th, March 30th for our final pretrial. Will that work for you, Mr. Crawshaw? Okay. So, Madam Clerk, I'll set the final pretrial. That'll be on March 30th. That will be here in Payson. That will be at 10:15 in the morning. I will allow the defendant to appear remotely for that hearing. I'm going to set a trial readiness notice hearing for March 17th at 1:30. That's in Globe. March 17th, 1:30 in Globe. And then finally, I'm going to set a 1:30. And Mr. Crawshaw, that's the hearing that as long as trial readiness notices are in, that hearing will be vacated. And then final status hearing for us, looking March 2nd. Well, yeah, March 2nd. Will that work for you, Mr. Crawshaw? Or what day? What part of the month are you trying to avoid? Okay, so I'm thinking then February 17th. Will that work for you? March 9th, I'll be in Globe, but if your client's going to be appearing remotely, that shouldn't be a problem. So March 9th, Madam Clerk, I'll set a status hearing. That'll be at 10:15 as well, and the defendant can appear remote on that one. Okay. So, Madam Clerk, let me just go over for all of us. March 9th, 10:15 in Globe, status remote. March 30th, pretrial conference, Payson, 10:15 remote. April 15th, jury trial here in Payson, and a trial readiness notice hearing on March 17th at 1:30. Okay. And Mr. Colongo, as I mentioned, if you fail to appear for the trial, it can go forward in your absence. If you fail to appear for any of the other hearings, they could go forward. Also, a warrant could issue for your arrest, or new charges of failure to appear could be filed. Do you understand that, sir? Okay, continue to stay in touch with Mr. Crawshaw, as I'm sure you have.
Okay.
And with that, we'll stand at recess on Mr. Colongo's matter. Thank you. Okay. And then, Madam Clerk, if you could let in Mr. Shepard and Mr. Shepard.
Your Honor, Shepard was having some audio issues when the last time, so he's going to try to see if he's
Okay, let's see.
able to hear.
And is he on Shepard?
Yes.
Okay, and Mr. Crawshaw, we're bringing in Mr. Shepard next. And Mr. Crawshaw, I have Mr. Chapman at 9:15. He still hasn't appeared. I don't know if you have a text number you can text him or something. Okay, excellent. Mr. Sheffer, are you able to hear us now? Excellent. Mr. Shepard, can you unmute your microphone for us? Mr. Shepard, if you can unmute your microphone, please. Okay, can you hear us, Mr. Shepard? Yeah. Mr. Shepard, we still, yes, I'll echo what Mr. Crawshaw indicated. And Mr. Shepard, I think what we're going to do is we're going to send you back. We're going to send you back to the waiting room. Maybe when you, oh, can we, Mr. Shepard? Okay. Okay. Next matter is State versus Shepard, CR 2023-465. I'll note that Mr. Shepard is appearing remotely. His attorney, Mr. Crawshaw, is remote. We have Mr. Sheffer from the probation staff, and we have Mr. Beckwith here from the county attorney's office. Let's see here. And Mr. Crawshaw, I'm looking, I think at the last hearing I had directed your client to appear in person. He had car trouble. I directed him to appear in person today. Can you give me any update on why he's not here in person today? I'm sorry, January 8th, you said? Okay, and Mr. Okay, thank you. And Mr. Beckwith, the state, is that correct? The state has no objection to a short continuance?
No, Your Honor.
Okay, and Mr. Crawshaw, I'm looking at January 20th for our next hearing then. Will that work for you? That's a Tuesday? Okay, Madam Clerk, I'll set a continued status, January 20th, 10:15. Time will be deemed excluded between now and then. Mr. Shepard, again, I'm going to direct that you be here in person. I realize things come up, but at some point my patience will wear thin, and I will issue a warrant, and we'll make sure we get you a ride, but continue to stay in touch with Mr. Crawshaw. Mr. Sheffer, you're aware of the interview that's set up for this week?
Yes, Judge.
Okay, and since our last hearing, has Mr. Shepard been reporting as is appropriate? Okay. Here's what I'm going to do. I'm going to admonish Mr. Shepard. Mr. Shepard, you need to continue to abide by all your terms. Mr. Sheffer, if that continues to be a problem, I guess at that point I'll expect to see a subsequent PTR. And at that point, if he's not complying and he can't do the basic things, then I'll probably issue a warrant for him at that point, and we'll have to take him into custody to make sure those things happen. So, Mr. Shepard, again, I'm just giving you fair warning. You need to make every effort to get those drug testing and your counseling done. If you have questions about that, talk to Mr. Crawshaw. Okay, Mr. Crawshaw, anything else today on Mr. Shepard? 10:15. And Mr. Crawshaw, I try to do yours backwards, like latest first. That way we don't have you here at 9 and then no hearings for an hour or so. That's typically the way I do it. Okay, that'll be all today. We'll see you back on that day, Mr. Shepard. Thank you. Thank you, Mr. Sheffer.
Thank you, Judge.
Mr. Chapman, if you want to make your way forward, please. Right there in that seat right there. You're done today, Mr. Shepard. Thank you. Didn't work. Print you out my notes. Yeah, good. Okay. Just want to make sure you don't have to use them, but I just want to make sure you have the option. Okay. Next matter is State versus Chapman, CR 2022-412. I'll know Mr. Chapman is present out of custody. Mr. Crawshaw, his attorney, is appearing remotely. Mr. Beckwith is here from the county attorney's office. We're here for a trial setting conference. Mr. Crawshaw, let me start with you. Do we just need to find a new trial date? Okay, and Mr. Crawshaw, realistically, if I put this anywhere before April, it's probably going to get bumped. Would you like me to just look for an April trial date? Okay, let's go ahead and address the other matter, and then we'll come back to another date. Okay.
It's due to be on the 9th of January, and then I don't know the exact rollout for how many days we'll be gone for. I know I can be gone for a maximum of 21 days, come back for 5, and then go back out again. I have my letter of employment from Rockwell a wildfire too, as well, on my phone that I got sent to me earlier this morning.
Okay. Okay, so it's 3 week chunks at a time.
Yeah,
Okay.
that's the max you can do without getting any days off until they make you come in for 5 or 4.
Mr. Beckwith, does the state have a position on the request that the defendant be allowed to work out of state? The court would require a waiver of extradition to be filed in advance of him leaving the state.
No objection.
Okay. So, Madam Clerk, if you could note that Mr. Crawshaw, I'll ask that you do 2 things. First, that you file a waiver of extradition for your clients. Secondly, that you file with the court his offer of employment. And he may go to the offer of employment for up to 3 weeks at a time. And so, Mr. Chapman,
Yes.
you'll need to make sure you're here at any hearings.
Okay.
If you fail to appear, we're going to get you here, and you're going to have a new Class 5 felony. I suspect that the state would file that without thinking twice. So make sure you do that.
Yes, sir.
Make sure you keep Mr. Crawshaw up to date on exactly where you'll be at any given time, so that he can get in touch with you as may be necessary, because if any court dates change, he will be there. Okay. Mr. Crawshaw, were you going to say something? Okay. Okay. Let me make a note. Mr. Crawshaw, I had a note that we possibly needed to do a Donald advisement today. Was there a new plea offer or not? Okay. Okay, then we won't do that. So, Mr. Crawshaw, I'm looking at stacking this on April 13th with the other trial we just set. Will that work for you? Mr. Beckwith, any issue with April 15th?
No, Your Honor.
So, Madam Clerk, I'll set this for jury trial, 3 days and 12 jurors. That'll be on April 15th. We'll begin jury selection at 9 a.m. I'll meet with counsel at 8:30. If you can note, that is a county-wide jury given the date of the offense. I'm going to set a final pretrial for you, sir. And that final pretrial is going to be on March 30th. And that March 30th date is going to be at 10 o'clock in the morning. Okay. So the next 2 times I'm going to see you will be March 30th at 10 a.m. here in Payson. You need to make sure you're here. You need to be here in person. And then also for trial, April 15th. If you fail to appear for either date, a warrant could issue for your arrest. New charges of failure to appear could be filed. If you fail to appear for the trial could go forward without you. Do you understand that?
Yes, sir.
Okay. Mr. Crawshaw, anything else on Mr. Chapman this morning? Oh, yes, and I will. Thank you, Mr. Crawshaw. I'll set a trial readiness hearing notice March 17th at 1:30 on my Globe calendar. Thank you, Mr. Crawshaw. Mr. Chapman, you don't necessarily need to be at that date. That's the date for the attorneys to make sure that they've filed their notices telling me whether they're ready or not for trial, so I can prioritize those. As of right now, you're going to be first in priority. Your case is quite old, so therefore it gets higher priority. Okay. Mr. Crawshaw, thank you for that. Anything else, Mr. Crawshaw? Mr. Beckwith, anything else?
No, Your Honor.
Okay, that's all today, sir. Thank you.
Thank you, sir.
Okay. All right. Okay, and he acknowledged that, Mr. Crawshaw. Thank you. Thank you. Let's see. Do we have Ms. Poplaski? Come on up to the table, ma'am. Okay. Next matter is State versus Poplaski, CR 2024-210. I'll note Ms. Poplaski is here in the courtroom. I'll note Mr. Crawshaw, her attorney, is appearing remotely. Mr. Alcorn is here. I'm sorry, no. Mr. Alcorn's case, Mr. Beckwith is here from the county attorney's office. This matter currently is set for trial on January 28th. Counsel, I'll let you know that Ms. Poplaski is second on priority on my calendar. She's behind the red matter. Both attorneys in red have filed a notice of readiness. I realize that the defendant may not be ready, but Mr. Brigida says it's not a legal matter. So, Mr. Crawshaw, can you give me an update on Ms. Poplaski's matter?
Yes, sir.
Okay. Okay.
Mr. Alcorn has no objection to continuing
Okay.
trial.
Given the fact that where the parties stand, Mr. Crawshaw's calendar, and also that as of right now, I plan on affirming the red matter, which is going to have priority over this. I think I am going to continue this based on the court congestion of the court's calendar. In just a moment, I'm going to get dates. Mr. Crawshaw, while we have Ms. Poplaski here, do you want to take a moment to try to set up when the next phone call or virtual or what, or next time the two of you will meet in person or somehow communicate?
Yes.
Okay. What time, Mr. Crawshaw? Okay. So, Ms. Poplaski, I'm going to direct that you Zoom with Mr. Crawshaw tomorrow, 2:30. I appreciate that Mr. Crawshaw was forthcoming and indicating because of his schedule he hasn't been able to communicate with you. Again, that's not your fault. I'm not going to hold that against you. You need to make sure that you work now. Now that he has availability, we do that. Okay? Excellent. Okay. Mr. Crawshaw, let me just take a look at when our arraignment date is on this matter. It's 6/3 of just a little bit. 3 of 24. Let me just see if I can get us in sometime before April, potentially. Let me look at... and Mr. Crawshaw, you're on the Stanfield matter, which is going to be a 3-week trial beginning this month. Okay, so probably. Okay, so February is not probably going to be realistic. If I'm looking out into March, what about March 18th? Or March 11th? Okay. 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 Okay, so you're suggesting April 15th? Does the state have any objection to that?
No, Your Honor.
So, Madam Clerk, I'm going to reset the trial out to April 15th. So that'll be your next trial date, ma'am. And as I've told you before, if you fail to appear for the trial and it's going, a warrant could issue for your arrest, but also the trial could go forward in your absence. As of right now, you'll be first in priority on April 15th. I'm also going to set a final pretrial for you on April 30th. That will be at 10 o'clock in the morning here in this courtroom. So both of those dates are here in Payson. 9 o'clock is when the jury will start. 8:30, I'll be meeting with the attorneys. Madam Clerk, that'll be 4 days with 12 jurors. And it will be a split jury panel. Okay, let me see here. I'm sorry, March 30th, April 15th. That I think I made both April 15th. I put the April 12th because I was thinking of the jurors' days. So April 15th, March 30th.
What time on March 30th?
March 30th, I set that at 10 o'clock. And then I'll finally set a trial readiness notice hearing for March 17th at 1:30. You don't need to worry about that date, ma'am. That date's for the attorneys. Okay, and that's on my globe calendar. Okay, Mr. Crawshaw, anything else today on Ms. Poplaski? Mr. Beckwith, anything else from the state on Ms. Poplaski?
No, Your Honor.
Okay, that'll be all today, ma'am. Thank you.
Thank you.
Okay. And Mr. Crawshaw, is that your last matter you had with me this morning? I appreciate that.
Oh, no, you're fine.
Okay, have a good rest of your day, Mr. Crawshaw. Okay.
He's asking about this one. So there's no clue. He says he did.
Is it Stephen with a PH or it's Steve S-V-E-N? S-D-E-V-E-N? Okay.
But because he just said he did file them.
Okay. Is that 2021 401? He has several cases, right? Let's see here. Looks like I'm showing his next hearing is pretrial February 17th and a jury trial on March 4th. I'm not sure which of those three cases. Okay, thank you. Yes, thank you. Have a good rest of your day. Mr. DeBrigida, are we ready on your matters or are we ready for a short recess?
I just need a really
Maybe we have a short recess.
What?
I was going to ask for a recess.
Okay. Let's plan on coming back at 10:15.
Okay.
Mark, Mr. Price. Oh, Price isn't until 11:15. Okay. And then Poplaski we did. Okay. So Mark, we're going to break till 10:15. That way Mr. DeBrigida can get a couple of his ready to go. Go from there.
So he knows. He's
Okay. We'll stand at recess till 10:15.
All right. It's not going to.
no. So I made a note that we're in the trial on that.
Conceivably, is he eligible for the 60? There are some possessory drugs.
see who we have. Okay. Okay. Next matter will be State versus Baltz, CR 2025-184. I'll note that Mr. Baltz is present out of custody. Mr. DeBrigida, his attorney, is here. Mr. Beckwith's here from the county attorney's office. At our last hearing, which was a pretrial, I had vacated the January 7th trial. There was a new offer. My understanding was that it expired today. We're here for a change of plea, possibly today. Mr. DeBrigida, can you give me an update?
Yes, Judge. A few days ago, I got a late Christmas gift from Mr. Beckwith, which was a revised plea agreement. I was able to briefly go over it with Mr. Baltz. There are some questions about some changes that still need to be done to the agreement that we're hoping to resolve in short order. So we would like to reset the change of plea for about 2 weeks if possible.
And is there a deadline on the plea agreement that allows
I
that?
guess it'll be another 2 weeks.
It can be extended.
Okay. So January 20th, Mr. DeBrigida?
Yes.
Okay. Mr. Baltz, I'm going to continue your matter out to January 20th at 11:15. Make sure you're present on that date. Time will be deemed excluded between now and then. And sir, that is a Tuesday because that Monday is a holiday. So make sure you're here on Tuesday, not Monday.
Yes, Your Honor.
Okay, and that'll be a change of plea.
What was the time, Judge?
11:15.
Thank you.
Okay, Mr. DeBrigida, anything else on Mr. Baltz?
Not right now.
Mr. Beckwith, anything else?
No, Your Honor.
Okay, that'll be all today, sir.
Thank you.
And Judge, Mr. Garcia advises he's about 55 minutes out.
Okay. Let me see if there's some of your other folks that we can do if they're
Let's see,
non-victim matters.
Mr. Red. Oh, Mr. Red is here. Oh, no, I know you're here, sir. We're just looking at the list. There's Mr. DeWert. He's here.
Yeah, let me just see what.
Mr. Red, I did speak with him yesterday. He should be here.
Let me see on Mr. DeWert's matter. Let's do Mr. DeWert's matter.
Okay.
Mr. DeWert?
Oh, I believe there's a new plea agreement.
You need a moment to
I
review
do need a
those?
moment, Judge.
Okay, and I realize one of his actually is a victim matter, so by the time you do that, we'll probably be back on schedule.
That's fine, Judge.
So, basically, the assault case is being dismissed in its entirety. And you just have the possession of the paraphernalia that's left. Okay. And then probation.
Oh, this is not the right one.
Just real quick, just so you know, when I CBS this morning, I had a prescription for some boxing prior to this day, but they have to get it
You
from
what?
my doctors.
You know what? There's foam in those windows.
So
Yeah, we really need some trees.
had a prescription for that.
Because that corner is the one that's closest to the highway. But trees, we need trees.
It's like it's in service.
Yeah. Better than it was, but.
Let's see. Yeah, it's a small general if I bring it down.
Here's the issue. So Marina sent me this on Friday, late Friday, because we determined that he's Prop 200 eligible, so there is no jail term. So she sent me this one late Friday that doesn't have it anymore. So you may want to move it 2 weeks just to make sure that
Okay. This is Mariana's.
What?
This is Mariana's
Mhm.
plea. Okay, yeah, we can do that.
Okay. Judge, we can call it.
Okay, just a second here. 323. Okay, next matters are State versus DeWert, CR 2024, 239 and 251. I'll note Mr. DeWert is present out of custody. Mr. DeBrigida, his attorney, is here. Mr. Beckwith is here from the county attorney's office. We're here for a pretrial conference in the 251 matter, a status in the other matter, and we have a January 28th trial. Counsel, I'll let you know as of right now. Just see here. Okay. I lose this. Oh. Word. And this matter is currently second in line now behind Mr. Red. Mr. DeBrigida, I saw that you filed a trial readiness notice on Red, indicating you were ready. Your client may have some concerns. The courts at this point is inclined to move forward with the Red matter, and so this matter would get bumped. So can you give me an update, Mr. DeBrigida, where we stand?
I can, Judge, and despite the party's best efforts, especially Ms. Cheskis, we weren't able to finalize, at least get a hard copy of the final agreement that the parties reached late Friday.
Okay.
And I absolutely do appreciate Ms. Cheskis working so hard on that. We are going to resolve this by agreement. It's just that the printed out version that Mr. Beckwith had is not the same version that I've received, and my client and I need to discuss a few things about it anyway. But it's a very favorable plea to my client and actually results in the complete dismissal of one of the cause numbers. So we just have to hammer out the details of that. I do not expect this matter to go forward to trial.
Is 2 weeks sufficient time to do that?
I believe so.
Mr. Beckwith, any objection if I set this for a change of plea on the 20th and then vacate our current trial date?
No objection, Your Honor.
Okay. So, Mr. DeWert, I'm going to set you for a change of plea on January 20th at 10:30. That's in 2 weeks, not from today, but from tomorrow. Monday's a holiday that week. Madam Clerk, I'll find that time is excluded between now and then on the 239 matter, and I'll find that time is excluded between now and any future trial date on the 251 matter. I'll vacate the trial that's currently set for January 28th. And Mr. DeWert, as I've told you in the past, if you fail to appear, a warrant could issue for your arrest. New charges of failure to appear could be filed. Mr. DeBrigida, is that contemplate a prison or a probation offer?
Probation.
Okay. So it sounds like Mr. DeBrigida, if you fail to appear, you probably lose the offer that Mr. DeBrigida has negotiated for you. So make sure you're here. I think you've been here in all past times. So I'll just do that. Okay. Mr. DeBrigida, anything else on the DeWert matters?
I just didn't catch the time on the 20th, Judge.
And Madam Clerk, I said 11:50? No, 10:30. 10:30.
Thank you.
Okay, Mr. Beckwith, anything else on this matter?
Thank you, Your Honor.
Appreciate it.
That's all.
I will. All right. Absolutely.
Yes. Yeah. If you can come by as soon as I'm done with court this morning, I'll look at it. Can you process warrants if I sign them, or will we need to go to the board to do that? Okay, like over the noon hour though? Warrants over the noon, like if not an arrest warrant, but a search warrant.
I haven't done one.
Okay, so if you could just work with Globe and find out if I sign it, if we just find out what it needs to do. Okay. Because I think he's probably just because I can do it, but then I'm not sure where that leaves it.
I think they do.
Okay, so maybe to just shoot a text to Adrian and just say if we have if Judge signs off on some search warrants today, how we can get a process. Thank you, Mark. Oh, you can do that? Oh, she's gonna do it. Okay, so let's just do it at the end of the morning calendar. So 11:45, maybe show up and bring a book. Okay, let's see. Is Mr. McHugh here? Come on up, Mr. McHugh.
What are we doing today?
One second.
Thanks for checking. You good if I go to the next one? Okay. Next matter is State versus McHugh, CR 2025-412. I'll note Mr. McHugh is present out of custody, represented by Mr. DeBrigida. Mr. Beckwith's here from the County Attorney's Office. We're here for a trial setting, possible change of plea. This matter was originally set for jury trial this week, but the state has not filed a motion to continue that the court granted. Mr. DeBrigida, where do we stand on the McHugh matter?
Judge, I think we're at a point where we're just going to set a new trial date. I'm going to speak with the prosecutor about a settlement conference.
Oh, okay. And that's is Mr. Alcorn, would he be amenable, do you know, Mr. Beckwith, for a settlement conference?
He listed that he is not.
Okay, well, if we don't have both parties participating, it's not going to be helpful. Okay, so Mr. McHugh, I'm going to set, again, three new dates in your case. Two will be for you, one additional one will be for Mr. DeBrigida. And Mr. Beckwith, this is still 3 days, 8 jurors, is that correct?
Correct.
Okay, and let's see here, this has a arraignment date of 8/25. Mr. DeBrigida, let's see here. There. About March 11th.
No, it would have to be the following week, Judge.
Okay. The March 18th would work
Yes.
for you? Okay. And Mr. Beckwith, any issue with March 18th?
No, Your Honor, but Mr. Elkhorn's notes state that he is okay with continuing this case to next week or setting it to trial.
Okay. So we'll go ahead and get it on the trial calendar. If there is some negotiations that can take place, Mr. DeBrigida can always reach out on that.
Well, Judge, I would like to possibly set a status conference
Okay.
next week.
Next week?
Yeah, originally the plea offer was set to expire on the 12th, which is next week.
Okay.
But the issue with that was at the time, this was considered a globe case because my client was in custody.
Okay.
He's not anymore
And where does he reside?
in this area.
Strawberry.
So I'll set it for I'll set it for jury trial with our final pretrial, and then set a virtual status for him next week in
Yes,
Globe.
please.
And then if he needs
You don't
to,
have
he
to
can
go to
make the
Globe.
trip if he
I
needs
don't
to.
have
You don't have to travel to the globe.
Okay.
You can appear virtually.
Okay.
Unless, I mean, there's a possibility that if all of a sudden that's the deadline and you want to do something, you might have to travel there. But otherwise, it'll just be a call-in right now.
Okay.
Obviously, Mr. Alcorn and I have a couple of issues to talk about this week. So.
Okay. So I'm going to actually set then three dates, Madam Clerk. First, January 12th at 11:15 on my Globe calendar. I'll set a status hearing. That'll be all virtual. And then I'm going to set a jury trial. The jury trial will be on March 18th. That will be 3 days, 8 jurors here in Payson. We'll begin at 9, and I'll meet with attorneys at 8:30. I'll set a final pretrial for March 2nd. That final pretrial will be at 10:30 in the morning.
The March dates are here.
Okay.
And then finally, I'll set a trial readiness hearing for February 17th at 1:30. And counsel will need to be there in person if their trial readiness notices are not filed. The 17th at 1:30 in Globe for that one.
What?
So
February
trial readiness
17th?
notice February 17th at 1:30 in Globe. Sure, you don't need to be there. That's for the attorneys.
Okay.
If they don't have their notices of whether the trial's ready to go, they have to be there in person and tell me why they don't have those done.
Okay.
Okay, make sure you're here. So status, January 12th, 1 week, virtual. Mr. DeBrigida will get you a Zoom call-in number.
Okay.
Then if that doesn't resolve it, March 2nd here in Payson. And then finally, March 18th for jury trial. If you fail to appear for any of those dates, a warrant could issue for your arrest. New charges of failure to appear could be filed. If you fail to appear for the jury trial, that could go forward in your absence. Do you understand that?
Yes.
Okay. And that will be all today. Thank you, sir.
Thank you. Probably give you a call tomorrow. Okay.
Mr. Galante, come on up. Is it Gallant or Galante? Okay. Go ahead and have a seat. So after I review it, then we'll have them scan it. Okay, good, thank you. Okay, next matters are State versus Galante, CR matter, CR 2025-323. Mr. Galante is appearing in person out of custody. Mr. DeBrigida, his attorney, is here. Mr. Beckwith is here from the county attorney's office. This currently is set for trial on the 21st of this month. As of right now, the Vickers matter has been affirmed and summonses have been issued. So this matter is going to get bumped. Mr. DeBrigida, are we still on the trial track for this?
I believe we are, Judge.
Okay. And Mr. Beckwith, I think this is your matter. We had it set for 3 days and 8 jurors. Do we still anticipate 3 days will be necessary?
Just to err on the side of caution, yes, Your Honor.
Okay. So, Madam Clerk, I'm going to bump the trial, but due to the court's congestion of the calendar. So, Mr. Galante, unfortunately, your trial's not going to be able to go forward on the 21st because there's a case older than yours that's ready to go on that date. Let's see here. And Mr. DeBrigida, you were not available on March 11th.
Correct.
Let's see how old we are, 7-5. I'm afraid if we go earlier than that, we're going to get bumped just by time. So probably either April 1st or the March 18th date we can stack. Which would you prefer, Mr. DeBrigida?
I'm fine with setting it on March 18th and see where we're at.
Okay. Mr. Beckwith, any issue with that?
No, Your Honor.
Okay, Mr. Galante, I'm going to reset the trial for March 18th. That will be here in Payson. Madam Clerk, that's a county-wide jury pool, so if you could note that in the minute entry for me. We'll begin at 9 o'clock, and I'll meet with counsel at 8:30. I'll set a final pretrial conference for March 2nd. I'll utilize the 10:30 time slot for that. I'll also set a final or a trial readiness conference notice hearing for February 17th at 1:30. You don't need to be on the February 17th date, sir, but you do need to be here March 2nd and also March 18th. If you fail to appear for either of those dates, a warrant could issue for your arrest. If you fail to appear for the trial could go forward in your absence. Do you understand that?
Yes, sir.
Okay. Mr. DeBrigida, anything else on Mr. Galante?
Not that I can think of, Your Honor.
And Mr. Beckwith, anything else on Mr. Galante?
No, Your Honor.
Okay, and let me just ask counsel, this is a drug case. Are all lab results in? And other than me bumping it, would the parties have been ready, or does other matters?
No, we filed a motion to continue because we just. Yeah.
Okay, and there was a bunch of things that blitzed me over the last week, and I was out of town, so I hadn't processed them all. But okay, so you believe though, if everyone's ready, we'll have the results back by that date. We should by March.
By March? Yes, of course.
Okay.
Yes.
Excellent. Okay, that's all today, sir. Thank you. Yes, 1:30. 1:30 Globe.
Miss,
Mr. White, come on up. Okay. Okay, next matter is State versus White, CR 2025-266. Note that Mr. White is present, out of custody, represented by Mr. DeBrigida, and Mr. Beckwith is here from the County Attorney's Office. Mr. DeBrigida, is your client ready to move forward with sentencing today?
yes, Your Honor.
Mr. White, can you tell me your full true name?
Richard Calvin White.
What's your date of birth?
January 3rd, 1979.
Okay. Court has previously accepted the plea. The court will now accept the terms of the plea agreement. It is the judgment of the court, Mr. White, that you're guilty of count 3, endangerment, a class 6, non-dangerous, non-repetitive, undesignated offense from April 8th of this year, and also count 1, aggravated DUI with a child present, having a blood alcohol level. And counsel, let me just see here. If I find that his blood alcohol level was exceeded 1.5, then I think I'm going to have to sentence him under the misdemeanor extreme DUI. Is that on there? Count 3. Okay. Let's see here. Currently. Counsel, I think if I find that it was an extreme DUI, which is the underlying offense, I'm not going to be able to do the 10 days with 9 suspended. There's going to be more days than that, which I need to look up. So, can I verify? The plea does say that it's an extreme, and therefore there's going to be more days. Is that the party's contemplation? Mr. DeBrigida, was that your understanding?
Based on the blood alcohol content, that's correct.
Okay, and so 28, 13. 2. So is he gonna? The minimum then would be 30 days jail, counsel. I'm looking at 28-1382 D1.
Right, but then after a certain percentage of that is served, there can be,
Can you?
I believe it's 20%. This is what I was speaking of earlier with the confusion related to mandatory minimum DUI sentence.
But I'm looking under. If he has a prior, then it's 120 with 60 suspended. But I think it's. Is there a portion?
If it's a
of 30
prior extreme.
Right, just a second. But is.
I believe it's under subsection I, Judge.
Okay. Let's see here. I don't do many of these. Oh, just a second. Section A1. Okay, so he's required to do 9 days then.
Right,
Okay, so I sentence him to 30, but he's required to do 9.
right.
Okay, so that's different than what's in the pre-sentence report. So he would have an additional 7 days that he would need to do. Okay, let me get back to my script. Okay, and so again, guilty of count 3, endangerment, a class 6, non-dangerous, non-repetitive, undesignated offense, and count 1, aggravated DUI with an extreme alcohol concentration exceeding 0.15, a class 6, non-dangerous, non-repetitive offense. I've reviewed the pre-sentence report. Other than the jail time, which it's recommending 10 with 9 suspended, I believe it would need to be 30 with 21 days suspended and then 2 days credit. The court is inclined to move forward with that. Mr. Beckwith, do you have any update on restitution and anything else you'd like to add?
No, Your Honor.
Mr. DeBrigida, I'll hear from you and or your client.
Judge, we're asking you to follow the recommendations of the probation department. Obviously, the court is required to impose mandatory minimum jail term, and we would ask that it be the minimum, of course. I don't believe there is going to be any request for restitution, so I don't know that we need to do anything more with that.
Okay, thank you. And Mr. White, would you like to add anything today?
Yes. I had met with, or not met with, but spoke with folks from Arizona probation about a month ago. Someone from Gila County, I can't remember the officer's name, but they transferred my paperwork. They needed some more information to Officer Mansour here in Payson. And so,
Officer Mansour is right here.
oh,
Yes.
okay. We talked last week. So I was just, I know we're supposed to be getting some information, paperwork transferred over to New Mexico to kind of see what the protocol is.
Right.
In your honor, I did look at the PSR, it doesn't have Officer Smith, but it is $200 interstate transfer fee.
Okay.
So we won't be asking for $65 per month, but we'll ask for the $200 transfer fee.
Okay. And did she leave? She did leave off the 65. She just didn't put in the 200.
Yes.
Okay. Okay. Mr. White, anything else you'd like to add?
No, not at the moment.
And Mr. White, when would you like to do the additional 7 days? Are you prepared to do that today, or check in today?
No, not today. I have a hearing for the state of Montana for an update to my parenting plan for my kids.
Okay. So when would you like to begin your 7 days?
Let's see.
And I will need a check-in form for the jail.
Need a calendar.
Your Honor.
I can do that on the 20th.
Okay. Sorry. Mr. Beckwith?
We have a victim requesting to make a statement on Zoom.
Oh, okay. Can we let in Miss Morrison? Thank you, Mr. Beckwith. Okay, fine. Miss Morrison, this is Judge Wright. If you can unmute your microphone. And ma'am, am I correct? You're the victim representative on the White matter? Okay, and I apologize that we are bringing you in a little late. We're getting towards the end of Mr. White's sentencing. The sentence that's stipulated is 36 months of supervised probation. He's going to be doing 30 days in jail. 21 of those by statute will be suspended, and he has credit for 2 days, so he's going to do an additional 9 days. I understand you'd like to make a statement? Okay, go ahead.
application.
Okay. Okay. And let me ask you, ma'am, do you have any family court? Do you have a family court case in place at all, either in state court or in tribal court? Okay. and ultimately, that's something that the judge on that case can take into account. So, okay. Well, following today's hearing, this case will no longer be pending, so that won't be an issue. Okay, and ma'am, I'm going to need to move forward now. Okay, thank you for being with us. Okay, so the court's going to find one mitigator, which is substance abuse. I'm sorry. And I'd heard from both sides, I believe, and then Mr. Beckwith had brought up the victim. Okay, the court's going to find one mitigator, which is substance abuse. I'll find one aggravator, which is victim harm. The court will find that probation is appropriate. As to count 3, it is the judgment of the court that imposition of sentence is suspended. The defendant will be placed on supervised probation for a period of 36 months. As to count 1, the aggravated DUI, again, the court will find that probation is appropriate. It is the judgment of the court that imposition of sentence is suspended. The defendant will be placed on supervised probation for a period, again, of 36 months. Those will be concurrent probationary terms. Mr. White, I'm going to go over some of the terms of your probation. We'll need you to sign for them before you leave today. I'll order the following financial obligations. Restitution will be left open for 90 days. I'll order a $20 time payment fee, $20 probation assessment, the $13, $9, and $2 assessments, $750 mandatory fine, $592.50 surcharge, the $20 court security fee, $750 to the cost of prosecution, $250 to the DUI abatement fund, $1,500 to the prison construction and operations fund, $1,500 to the public safety equipment fund, and $4 to the police equipment fund. I'll order that you make monthly payments of at least $150 on those obligations beginning February 5th until paid in full. If there is restitution, all payments will be made towards restitution first. I'll also order that the defendant pay a $200 interstate compact fee so that he can be supervised out of state. I'm going to order that the defendant serve 30 days in the Gila County Jail. 21 of those days will be suspended upon successful completion of a substance abuse screen and any recommended treatment. I'll find that he has 2 days credit, therefore he's going to need to do an additional 7 days. And Mr. White, when did you say you wanted to check in for those 7 days?
Let me see. I'll have to verify.
It sounds like there's a hearing on the 20th, so you don't want to miss your family court hearing.
Yeah. I can report on the 22nd.
Okay, so I'll order that the defendant report to the Gila County Jail on January 22nd. I'll order that you be there no later than 1:30 to check in. I'll order that he serve 7 consecutive days and that then he will be released after that. Sir, if you fail to appear for your jail sentence, I believe that can be treated like an escape charge. So that creates additional issues for you. And you'll need to check in. We're going to give you paperwork today showing it's a get into jail paper. You'll need to have that when you report. Order, as I've indicated, that you successfully complete a substance abuse screen and any recommended treatment. During your probationary period, you're not to consume alcohol of any type, not to be in bars or liquor stores. Your conviction will be reported to the Arizona Department of Motor Vehicles. You're to comply with any interlock ignition device requirements that Arizona imposes. Pursuant to the plea, I'll also order that you complete the parenting program ordered through Wise Choice Alternatives. That is at your own expense. You're going to be on probation for each of these charges for a Class 6 felony. If you violate any terms of probation, you could be brought back into court. If the violation is proved, you could get up to 1 year in the Gila County Jail, up to 2 years 2 years prison on each, and up to a $150,000 fine. Do you understand that?
Yes.
You have the right to petition for post-conviction relief from the orders of this court and to have a lawyer represent you. If you cannot afford a lawyer, one would be appointed to you. If you cannot afford copies of the necessary records and transcripts, they will also be provided to you at no cost. If you want to petition for post-conviction relief, you need to file a notice within 90 days of today's date, or you lose your right to seek that relief. Order that all additional counts in this matter that are dismissed pursuant to the plea are hereby dismissed. Any bond is exonerated. Mr. Brigida, for the purpose of the advisory, are these your client's first felonies?
They are.
A felony conviction suspends your civil rights, the right to vote, serve as a juror, hold public office, and bear arms. If this is your first time felony offense upon completion of your probation or absolute discharge from prison, payment of all restitution, your right to vote, serve on a jury, or hold public office is automatically restored. Although these rights are automatically restored, you will need to re-register to vote. You can also file an application to set aside your judgment of conviction. Applications to restore civil rights can be obtained from the clerk of court at no cost and filed without a filing fee. Just a moment, I'll have you come up, sign for your review rights, and give us fingerprints, and also sign for your probationary terms. Mr. DeBridget, anything else?
I don't believe so, Judge.
Mr. Beckwith, anything else?
No, Your Honor.
And Ms. Morrison, if you have additional questions, I'll suggest that you reach out to the Victims Unit of the County Attorney's Office. If you're requesting specific restitution on behalf of the children, that will remain open for 90 days, so you need to reach out to the County Attorney's Office to get that done. Have a good rest of your day, Ms. Morrison. You're allowed to stay on the line if you want to watch while Mr. White comes up to sign for his review rights, etc. Sure, why don't you go over there? Mark will help you get signed in. Mr. Red, if you want to make your way up front, you'll be next.
How's your dad?
Not good.
Is he still in the hospital?
Yeah. They're not sure if he has a bowel blockage or if his.
Is that Brooks right there?
Yeah. The big one? Or there's two? Which one?
There's 4 of them.
Do I grab the one by itself?
Yeah. I thought I sent that upstairs.
28. Did it work, Mark? Thank you.
Then please follow instructions below.
That sounds like the same cover sheet.
Okay, now I'll text her or email her back.
Instructions below. And it's blank.
I don't know. I'm not sure what she's doing.
Are you doing paper prints right now, so you'll have me sign another time? That's fine. Who knows? Okay, I'm going to jump back up to Mr. Red, the top one at our 9:30 calendar. Okay, thank you, Ms. Morrison. Have a good rest of your day. And let's go ahead and bring in Jennings. And do you know what case Mr. Deck is zooming in for?
It's Mr. Burris.
Burris? Okay. Thank you. And Ms. Jennings, I see you're with us. It's going to be a few. You're about 3 down my list. Okay. Next matter is State versus Red. Actually, 3 matters: CR 2023, 244, 2535, and 2542. This is the date and time set for a pretrial in the 244 matter and a status in the other matter. I'll note Mr. Red is present out of custody, represented by Mr. DeBrigida. Mr. Beckwith is here from the County Attorney's Office. Counsel, I've reviewed the trial readiness notices that were recently filed. The state indicated they were ready. Mr. DeBrigida indicated from a legal perspective there was no reason why he would not be ready. He indicated that his client was asking for a delay given the health of his client's father. This is the matter that has highest priority on my calendar for January 8th, and the court is inclined at this point to affirm it. Mr. Beckwith, can I verify that the state is in fact ready?
Yes, Your Honor, and Ms. Ortman requests that the 244 matter only be the promoting prison contraband and the drug paraphernalia charges, and bifurcate the Ag DV.
Okay. Let me just see here. Okay, so she's asking that counts 3 and 4 be bifurcated so that the trial just move forward on 1 and 2.
That's correct. Yep.
Mr. DeBrigida, can you give me an update on readiness and also on the state's oral motion to bifurcate the two matters?
So, Judge, yesterday morning, Mr. Red did contact me and let me know that his father had to be taken by helicopter to the hospital. He remains hospitalized. His prognosis is unknown but not very good at this point, and his family needs him right now, especially if things take a turn for the worse.
More financially needed.
But I did by email let Ms. Workman know yesterday of what Mr. Brett had told me, and I am requesting that the trial be continued until we have a better idea of what's going on with my client and his family.
Okay.
I can understand why Ms. Workman would want to bifurcate it, because I believe that Mr. Brett's father is a witness in as to certain of the charges, but not to others.
And so what's your position on the state's
One
motion
second.
to bifurcate?
What do you want to say?
I'm not trying to put off the court or anything. It's just kind of everything. My parents lived, had to do pretty much everything for them. So it's just like they don't even operate without me anymore. I cook meals.
And Judge, just to kind of give a little more detail, given my client's responsibilities to his family, his parents are up in age. They are not in the best of health, obviously his father especially. But until arrangements can be made, until it's known what's going to happen, until arrangements can be made, my client would not be a good idea to go forward with this trial.
Okay. Let me just see. Is there actually? I think there's actually 4 matters. I apologize. I think I missed. There should be 2023, 244, 35, 40, and 42. Am I correct?
Yes.
Okay. So, Madam Clerk, there was one that missed the calendar, and I don't know if it's. There should be 4 matters: 23, 244, 25, 35, 25, 40, and 25, 42. So, if you could make a note of that. Okay. And Mr. DeBrigida, the court's going to. Well, a second. What's your position on the state's request to bifurcate?
I'm not going to take a position.
Okay. Which one was off the calendar? Which one was not on the calendar today? 40. And did it just not have? I wonder if it got left off last time. CR. Is it still active? I think.
What's the cost number?
2025-40. I think it had. So for some reason, it just got it just didn't get calendared for today. It was set by minute entry on October 6th. Yeah, it just got miscalendared. So, okay, so here's what I'm going to do today. I'm going to, Madam Clerk, I'm going to deny the defense request for a continuance of the trial. I'm going to affirm our January 28th trial. I'll grant the state's request to bifurcate the charges. Therefore, I'll note that the only 2 charges that will be moving forward on that date will be counts 1 and 2. I'll order that a jury be summoned and that case lines be opened. And then I will set a jury questionnaire review for the 26th of January on my globe calendar at 4 o'clock. Mr. Red may appear remotely for that if he chooses to.
For the next court.
Madam Clerk, if you can note that the
The
jury
20th.
panel will be a county-wide panel.
Wednesday.
4 o'clock.
Wednesday. No, that one's.
4
we don't
o'clock
need
for
to do
the jury
anything for that
review.
one.
Okay. And then, let me just see, did the
Just
other,
need to show up.
did the 23, 25, 35, does it
On the
already
20th.
have a status on the other date? Let me just make sure.
Yeah, if we can reach a resolution, we would probably come back
Yes, looks like
Tuesday
the other
the
ones-
20th because Monday
The
is
other ones
Martin
all
Luther
have
King
status
Day.
hearings on the trial date.
But I'll let you know after I talk to Ms.
Okay.
Ortman.
So, Mr. Red, the trial is on January 28th. We'll begin at 9 o'clock. I'll meet with the attorneys at 8:30. You need to be here. If you're not here, the trial will go forward without you. Do you understand that?
Yes, Your Honor.
And then on January 26th, we're going to have a hearing to go over jury questionnaires. I think you've done that before. You can choose to Zoom in for that hearing if you want to. You can be in person, it'll be in Globe, or you can just let Mr. DeBrigida handle it. It's up to you. Okay. Counsel, I will try to get a questionnaire summary out to you, or a jury questionnaire draft language out to you by end of day tomorrow. Okay. Mr. DeBrigida, anything else on Mr. Red?
No, thank you, Your Honor.
Mr. Beckwith?
No, Your Honor.
Okay, that'll be all then today, Mr. Red.
All right, I'll be talking to you.
Okay, after I speak with her.
Okay, you're good with what I did there? A lot of moving pieces, more than normal, I guess. Okay. And let's see. Is Mr. Burris here? Come on up, Mr. Burris. And Mr. Deck, are you with us? We can. Next matter is State versus Burris, CR 2019-440. I'll note that Mr. Burris is present, out of custody, represented by Mr. DeBrigida. His attorney, Mr. Beckwith, is here from the county attorney's office. Mr. Deck, his probation officer, is appearing remotely. Mr. DeBrigida, can you give me an update on Mr. Burris's matter?
Judge, Mr. Deck was kind enough to reach out to me to discuss Mr. Barris's situation. It sounds like something that should be able to be resolved, although I don't know, especially since the holiday break, whether Mr. Barris and Mr. Deck have had a chance to talk more about this.
Mr. Deck, have you had any attempts at informal resolution or other matters on this? Okay. Mr. DeBrigida, does that give you any additional information?
It does. I would just certainly encourage all parties to just keep moving forward.
Okay. So are you asking, do I need to set this for a hearing, or where does that leave us today?
I don't know if Mr. Deck has an idea of how long of a time it would be, additional time to resolve any of this. I'm sorry, I didn't hear.
You said you're unsure, Mr. Deck? You're unsure?
1 second.
Yes.
Judge, I'm gonna ask.
Can you turn on your microphone there?
I'm gonna ask if my client and Mr. Deck or somebody from probation can just get together this week and see what some sort of roadmap forward for how this can come to a conclusion.
Okay. Here's what I'm inclined to do. I'm inclined just to set this for a 30-minute hearing on February 2nd, and then if it can't be resolved, we'll have that quick hearing. I think he's on for narcotic drugs, so unless there's a refusal to do drug training, I don't think I'm going to have a lot of options.
Right.
Mr. DeBrigida, would you like to be heard on that? I think I have 10:45 to 11:15 available.
I think that's fine because we obviously want to bring the matter to a conclusion, but I'm also hopeful that there can be a resolution before then.
Mr. Beck, with any issue with that?
No, Your Honor.
Mr. Deck, are you around would you be available if you need to testify February 2nd in the morning? Okay, Madam Clerk, I'm going to set this for an evidentiary hearing, February 2nd at 10:15. I'll set aside 30 minutes for that. I'll order that case lines be opened. Mr. Burris, if the matter's not resolved by February 2nd, we're going to have an evidentiary hearing, and I'll determine whether you're in violation of your probation or not. If I find you in violation, we'll determine where it goes next. We can't just let the matter drag out forever. It looks like it's already been on my calendar for nearly 5 months, so it's got to come to a conclusion. Make sure you stay in touch with Mr. Deck. There's still a chance to get this informally resolved, but the time frame's pretty short to get that done. Okay, that'll be all today. Thank you, Mr. Burris.
You said 10:15, Your Honor.
10:45.
10:45. Okay,
10:45, half an hour's hearing set. Thank you, Mr. Deck. 10:45, yes. Okay. Okay. We're going to do the Jennings matter next. Miss Jennings, if you can unmute your microphone and camera.
How you're going to get it done.
Yeah.
I'm sure they'd like to move you off probation.
Yeah, because I'm going to set it off. So that's the issue.
That's the way to do it. Okay. Thank you, Your Honor.
Okay. You're all done, sir. Okay, Ms. Jennings, can you hear us? Okay. Next matter is State versus Jennings, CR 2025-509. I'll note that Ms. Jennings is appearing remotely. Mr. DeBrigida, her attorney, is here. Mr. Beckwith is here from the county attorney's office. Let me just see here. Okay. Mr. DeBrigida, can you give me an update on where we stand? We're here for a trial setting, possible change of plea.
The parties are proceeding with discovery. I don't believe it's concluded yet. Ms. Hamblin did reach out to me recently to discuss how we're going to try to resolve the case and some other issues and disclosure we need to work through. There's no offer pending yet. Ms. Hamblin and I are still talking about that. I don't believe we're at a point where we need to set trial. On behalf of Ms. Hamblin and myself, I am going to ask for the court's indulgence to reset this in about 30 days for another trial setting conference.
Mr. Beckwith, what's the state's position on where we're at today?
No objection to resetting so long as time is excluded.
Okay. And counsel, I'm inclined just to get this on the trial calendar. We can set a status hearing in 30 to 45 days and go from there. So Miss Jennings, I'm going to set several dates for you. Some of them will be virtual. Some of them will be in person. So if you have a pencil there, you want to get ready to write them down. Mr. DeBrigida, I'm looking at March 11th for our trial date. Does that work for you?
Judge, I think we already discussed that it did not.
Okay. And I apologize. I don't make notes every time. I'm going to write down DeBrigida. By the time I get it next hearing, it won't be ready. And then let's see here. Then how about
We're probably looking at
April 1st?
I would say later in April.
Okay. How about April 15th?
That's fine.
Okay, Mr. Beckwith, any issue calendar-wise that you know Ms. Hamblin has?
No, Your Honor.
So, Madam Clerk, I'm going to set this matter for jury trial, April 15th. That will be here in Payson. And counsel, is this 3 days and 8 jurors or 3 days and 12?
I have 3 days, 8 jurors.
Okay.
I believe it would be 8 as well.
3 days, 8 jurors. Will begin jury selection at 9. I'll meet with counsel at 8:30. I'm going to set a final pretrial for us on March 30th. That will be here in Payson, and that will be at 10:30 in the morning. I will allow Ms. Jennings to appear virtual for that matter. Ms. Jennings, if the matter goes to trial, you'll need to make sure you're here in person for that hearing. I'm then going to set a status hearing, and Ms. Jennings, you'll need to be present here in Payson for the status hearing. That's going to be on February 17th, and I will set that hearing at 10:30 in the morning. And then finally, Madam Clerk, I'll set a trial readiness hearing for March 17th at 1:30. That'll be on my globe calendar. So, Ms. Jennings, I'll see you on February 17th here in person. You can appear remotely for the March 30th date, and then you'll need to be here in person for trial on April 15th if the trial goes forward. Do you understand that? If you fail to appear for any of those dates, a warrant could issue for your arrest. New charges of failure to appear could be filed. If you fail to appear for the trial could go forward in your absence. Do you understand that? Okay. Mr. DeBrigida, anything else on Ms. Jennings today?
I don't believe so, Judge.
Let me just see. February 17th and then March. What time did I set the April 30th date?
10:30.
30. Okay.
March 30.
Okay. March 30th. Yes, thank you. Okay, that'll be all today then, ma'am. March 30th. 30. Yeah. Thank you. Okay. And Mr. Lawler?
Yes, sir.
Come on up. Yes.
He's got Lala right there.
Did I get the plate?
I just got a note that something went on last year downtown. Court. Oh, he is here. Okay. Sorry, I got an email.
Over here, sir. Oh, sorry. You're fine. I'm going to make you a copy of this before you leave here. Yeah.
Who's assigned to Lawler?
It is with me now.
Okay. Was it with someone else?
It was with Kayla, but then it came out of warrants and it was assigned to me.
Okay. Okay, I just
Wasn't really sure.
it's with Mr. Beckwith as the assigned
Case is
prosecutor.
with me. Yep. I don't know why she didn't just keep it.
Okay, you ready?
Because in Jen is
Okay, next matter is State versus Lawler, CR 2024-313. I'll note Mr. Lawler is present out of custody. Mr. Beckwith is here from the County Attorney's Office. We're here for a trial setting, possible change of plea. Mr. DeBrigida, can you give me an update on the case?
Yes, Judge. I have an offer from Ms. Evans that expires on the 19th. I presume she means the 20th since the 19th is a holiday. So I'd like to reset the 20th. Yeah. My client has some health issues he's addressing on the 15th, but I think if we could reset to the 20th, that would be fine.
Mr. Beckwith, any objection to that?
No objection.
And the plea expiration will be Tuesday the 20th, as Monday's the holiday.
Yes, it can be
Okay.
extended.
Mr. Lawler, I'm going to give this a 2-week extension. I'll see you back on January 20th at 10 a.m. Time will be deemed excluded between now and then. That's Tuesday because Monday's a holiday. Make sure between now and then you speak with Mr. DeBrigida. Madam Clerk, if you could also note, we'll possibly do a Donald advisement. Okay, that'll be all today, Mr. Lawler. Thank you. Do you need copies of that, Mr. DeBrigida?
Yes,
Mark, can you assist with those?
What time, Your Honor?
10 o'clock.
10 a.m. Okay, thank you.
Okay. And let's see, is Mr. Price here? Come on up, Mr. Price. Yeah.
Top one.
Next matters are State versus Price, CR 2025 442, 450, 453, and 455. Well, now Mr. Price is present out of custody, represented by Mr. DeBrigida. Mr. Beckwith is here on behalf of Mr. Alcorn from the County Attorney's Office. Mr. DeBrigida, it looks like I bumped this out in January. Can you give me an idea where we stand?
Yes, Judge. Obviously, there are 4 cause numbers. One of the previous times we met, I don't know if it was the last time, I had prepared a 15.2, but only for the 442. Subsequently, I received disclosure for the other matters as well. I still owe Mr. Alcorn 15.2s for those other matters. I'm also requesting, and Mr. Beckwith was kind enough to pass it along, that I need any digital disclosure so that I can go through that with my client. We don't have an offer yet, but I think the parties need additional time to complete disclosure.
If I were to continue it, I want to do a relatively short turnaround. Are you available in 2 weeks at 9:45? A little
Sure.
early.
Yes, Judge.
Mr. DeBrigida, I'm sorry, Mr. Beckwith, any objection with the waiver of time?
No objection, Your Honor.
So, sir, I'm going to continue your case out to 2 weeks from tomorrow, the 20th of January. That'll be at 9:45 in the morning. You need to make sure you stay in touch with Mr. DeBrigida. As he gets information, he's going to need to get it to you. That's a pretty short turnaround. Time will be deemed excluded between now and then. Okay, and counsel, I'll just let you know that we moved this a couple of times out. If we don't have it resolved next week, I'll probably just start setting trial dates. That doesn't preclude resolution, but hopefully it will move us along.
Certainly, Judge.
So, okay, that'll be all today, Mr. Price. 9:45.
Okay. Thanks.
Let's see. Tuesday. So it's Tuesday the 20th. That's my next Payson day, so it's 2 weeks out. Do you need a moment with Mr. Garcia? Do you need a moment with Mr.
Is
Garcia?
he here? Oh, no, I don't,
Okay,
actually.
is Mr. Garcia here? Come on up, sir. Have a seat next to Mr. DeBrigida.
We can talk. Congratulations. Making it here.
I was need one. Busy.
Fair.
What did it look like today?
We're just going to be setting some dates. When is your next court date in New Mexico?
I have no idea, to tell you the truth.
Huh?
I have no idea, to tell you the truth. I've been so worried about this one, I haven't even paid attention to those. I think it's coming up on 16th or so.
Okay. Next matter is State versus Garcia, CR 2023-356. I'll note that Mr. Garcia is present out of custody. It appears that he bonded out on the 29th of December. Mr. DeBrigida, his attorney, is here. Mr. Beckwith is here from the County Attorney's Office. Let me just take a look here as my computer pulls up. We're here today for a case management conference. I'll note that we already have a bond forfeiture hearing or a time slot on the 20th calendar at 11:30. So, Mr. DeBrigida, can you give me an idea of where we stand today?
A couple things, Judge. As you know, my client, you may not know, but you may not recall, my client came from a great distance to be here for this hearing because the court's minute entry indicated that he needed to be physically present. So he did honor that. There was some talk about whether he could appear virtually. Given the court's order and given the status, he was fine with doing it, but he did come a great distance for this. For the bond forfeiture hearing, I don't know that we'll get to that point. I'll need to speak with, I believe it was Mr. Duran, the attorney for the bonding company, about their position on all of this. But as it relates to the bond forfeiture hearing, I would ask that my client be allowed to appear virtually because he also has some matters he has to tend to in court in New Mexico.
Okay. And so are you just asking that I use that as a trial setting conference then?
That would make sense, Judge.
Mr. Beckwith, what's the state's position on whether I just continue this to the 20th for a trial setting?
No objection, Your Honor, but Deputy County Attorney Ryan Elkhorn does have notes here for me to address release conditions.
Okay. And I think I had indicated that I would review release conditions because he was in custody at the last hearing. He's now posted bond, a second bond. So there's the first bond that's subject to forfeiture. There's now the second bond. I'm not inclined to review release conditions today as he has bonded out on the second matter, at least today. So do you have notes that you'd like to further discuss that?
For the record, Mr. Alcorn requests that the defendant's previous conditions of release should be revoked and increased. The defendant's initial bond was $55,000, then was reduced by the court to $20,000. He committed new crimes, posted bonds, so the conditions of release were not sufficient to keep him, and it should be more.
Okay. I'm going to affirm the current release conditions today, which is $20,000 cash or surety. The defendant has posted that. I'm going to affirm the bond forfeiture hearing, which is set for the 20th at 11:30. I'm also going to set that as a trial setting hearing. I will allow the defendant to appear virtually for that hearing. You need to make sure you're on the Zoom, have good internet access wherever you're at 11:30 that date. We'll discuss whether the first bond is going to be forfeited and whether what the next step is, whether getting this case on the trial calendar. Okay. Okay. Time will be deemed excluded between today's date and that date. Mr. DeBridget, anything else?
Not right now, Judge.
Okay. And is Mr. DeBridget, is your client residing out of state right now?
In New Mexico, Judge.
Okay. I'm going to note I'll allow the defendant, and does he has pending matters in New Mexico?
Yes, Judge.
So it's sort of probably a catch-22. New Mexico could say don't leave New Mexico. Arizona could say don't leave Arizona.
And the court may recall that these matters have been pending for some time.
Right.
He's always lived in New Mexico, but
okay. So I am, Madam Clerk, if you could note, the court will allow him to reside in the state of New Mexico as long as he complies with all of his other pretrial release conditions, both of Arizona and New Mexico. Okay, so I'll see you back on that day, sir. That'll be all today.
Thank you, Your Honor. You have a wonderful afternoon.
thank you. Okay. Give me a second. I'll be out.
Okay, thank you.
Is Mr. Morton here? Come on up, sir.
Oh, where's Mr. Jones?
How are you?
Good, sir. How are you?
Okay.
Mr. Jones to make a copy of this for us. Just received this.
Okay. That's a plea.
Mm-hmm.
What's it saying?
It means you can earn a misdemeanor.
What's that?
Basically, they're allowing you to plead to an undesignated offense. And if you successfully complete probation, it would be a misdemeanor only.
Oh, I see.
We'll talk more about it.
Okay. Next matter is State versus Morton, CR 2025-415. I'll note that Mr. Morton is present out of custody, represented by Mr. DeBrigida. Mr. Beckwith is here from the county attorney's office. We're here for a status hearing. We have a jury trial that's currently set on March 4th. In council, I'll let you know that,
We're not going to need it.
let's see. Okay. Mr. Morton, I don't know why he is out of custody. I don't know why he was noted as in custody. So, Mr. DeBrigida, can you give me an update on where we stand?
Yes, Your Honor. Ms. Evans has provided an offer to an undesignated offense. It expires January 26th.
Okay. And is that something your clients, would you like me to set a continued status?
Yes, please.
Okay, and the 26th, does your client live here in Payson?
No, I live in Phoenix now.
Okay, so Mr. DeBridget, if I set it on the 26th in Globe, that'll be okay?
It doesn't matter, Phoenix or Globe. What part of, I'm sorry, Payson or Globe?
I would rather Globe.
Okay.
What part of Phoenix are you in?
So, Madam
West.
Clerk, I'm gonna affirm the trial as of today,
We can
but
go to
I'm
my
gonna set a
office then.
continued status hearing for January 26th. That'll be on my Globe calendar. That will be at 11 a.m.
26.
And Mr. DeBrigida, that's something that if it's an undesignated offense and you think an abbreviated pre-sentence report would work, if your client wants to do that, we could potentially move forward with sentencing if that's an option.
I'll check with Ms. Evans on that, Judge.
And you'll need to get with Ms. Smith probably by the end of week, so she has at least a couple of weeks to look into that.
Right.
Okay, so sir, one option sometimes is we can go, if you decide to take the plea, we could potentially go change a plea and sentencing all in one day to avoid you just traveling back and forth. You can talk to Mr. DeBridget about what that means, what your rights are. You always have a right to a full report, etc. But sometimes folks want to do it a little quicker.
Okay.
Okay, so make sure you're in in Globe.
Globe.
Globe, 26th, 11 a.m. I'll see you then.
Perfect.
Thank you.
Thank you.
Don't need
Thank
to
you.
rest time because the trial's firm.
Wait, Mark,
Okay,
can
thanks.
a copy of that for us?
Okay.
But we can, my office is on like 101 and 51st Avenue in North Carolina.
Yeah, I can get
We
there
can get
whenever it's
together there.
thrown.
All right.
So exactly, just taking that plea then.
Well, we'll talk about the pros and cons of it, but it's a very good offer.
Okay. Well, yeah, but
That's it. I don't need it.
thank you. Yeah, especially if it keeps me from getting a
If
felony.
you'd like to
Give me
make
a
your way
call
up
later
front,
this
as
week.
soon as the chair is
Okay.
available.
Yeah, good. You're good to go.
Can we write down the next court date? Just
It
put
is
up
right
there.
here.
Oh, is it on here?
That's
already?
it.
Perfect.
Yep.
Thank
But
you.
that's in Globe.
Okay.
Okay.
Thank you. Have a
Thank
good day.
you.
Thank you. Thank you, sir.
Okay, next matter is State versus Brooks. CR 2025-123. I'll note that Ms. Brooks is present, out of custody in person. Mr. DeBrigida, her attorney, is here. Mr. Beckwith, the assigned prosecutor, is here as well. We're here for a trial setting conference, and I think when we were here in December, Mr. Beckwith had indicated they had another submittal under review. But let me go ahead and start with you, Mr. DeBrigida. Where are we standing today?
Judge, I was advised by my client and her family that there was paperwork served on them for the new case. So I believe I think we're supposed to be having an arraignment today.
Set for arraignment today at 3:30.
Oh,
What's an arraignment?
just didn't get.
You just advised of the new charges.
Let's do this. And it's not a victim matter, is it?
No.
No, Judge.
We could go ahead and do arraignments. Oh, it did. I don't know why it didn't get collapsed to the same time. Let me just see here.
Should have been at this time.
I did it.
In fact, I think your daughter asked me about
Okay. So,
Can I get a copy of the discovery?
Madam Clerk, I'm also going to call CR 2025-563 from our 3:30 calendar. Mr. DeBrigida, have you had a chance to review the indictment with the new indictment with your clients?
I did.
And is her name spelled correctly? And are you willing to waive a full formal reading?
Judge, we can waive a full formal reading, enter pleas of not guilty as to each charge.
Okay. So, Ms. Brooks, I'll enter your not guilty plea. A denial as to any sentence enhancing allegations on the new case. Let's see here.
What is that cost? What is that cost number, Judge?
25,563.
563. Thank you.
Yes. Okay. Let's do this. Okay. And so let me just pull back up the case at hand. And so, Counsel, what I'm inclined to do is set this for a trial setting, possible change of plea in about 4 weeks. Mr. DeBrigida, would you like that so you can get all the paperwork and go from there?
Yes, Your Honor.
Okay, and Mr. Beckwith, this is your matter. Any objection to that?
No objection.
Okay, I think I'm going to go out to February 17th, which is actually about 6 weeks out, just to give a little more room on my calendar. So, ma'am, your next hearing is going to be February 17th, which is a Tuesday, here in Globe. That'll be or here in Payson, excuse me.
Monday's a holiday.
At 10:45 in the morning is what that will be. Between now and then, make sure you continue to stay in touch with Mr. DeBrigida. If the matters aren't resolved at that point, then I'll probably go ahead and get them on my trial calendar, at least one of them, and then we can. It doesn't prevent the matters from being resolved without a trial, but that way we make sure that they keep moving. Okay, time will be deemed excluded on the old matter. Mr. DeBrigida, anything else today?
No, thank you, Judge.
Mr. Beckwith, anything else today?
No, Your Honor.
Okay, that's all today, ma'am. Thank you.
So, I'll talk to you real quick.
Okay, good. He'll be next as soon as I get caught up on my notes and Mr. DeBrigida is done talking to Ms. Brooks.
Thank you. So obviously you don't have to come back at 3:30.
Okay. Yeah, we're trying to figure it out.
You don't have to come back at 3:30.
Okay, thank you.
Okay.
Oh, and Madam Clerk, can you note, I'm formally going to appoint Mr. DeBrigida on the new one. I don't know, just so that everyone's aware of that. Thank you. Okay, final matter of the morning is State versus McCune, CR 2024-325. I'll note Mr. McCune is present out of custody, represented by Mr. DeBrigida. Mr. Beckwith is here from the County Attorney's Office. We're here for a trial setting, possible change of plea, and potential Donald advisements. Mr. DeBrigida, can you give me an update on Mr. McCune's matter?
Yes, Judge. May I have a moment, Judge?
Yes.
An issue.
If you need to step in the side room,
Yeah,
I'm just
why
going to
don't we
remain
do
on the
that?
bench.
You see the Cardinals fired our coach?
Oh no, I missed it.
Yeah.
I'm not shocked.
Gannon's gone.
Good.
Yeah.
He should be. Should our quarterback?
Oh yeah, Kyler Murray.
He needs to go next.
I think he's on the way out. Well, the thing is, I don't know who's going to want to pick him up because it was such a big contract we gave him.
I know.
Who's going to want to pay that?
Thank you, Your Honor.
Okay, just a moment.
Mm-hmm.
Okay.
My week will get more calmed down as it goes on. Monday, well, that and just generally Mondays and
Okay.
Tuesdays are my
Next matter
busiest
is
days.
State versus McCune, CR 2024-325. Mr. McCune is present out of custody. His attorney, Mr. DeBrigida, is here. Mr. Beckwith is here from the county attorney's office. Mr. DeBrigida, can you give me an update?
Yes, Judge, and I checked with Mr. Beckwith just to be sure, but I would have liked to have had better communication with Ms. Ortman, but the holidays I think were got in the way of that. I would like to reset for a couple weeks. I don't think we need to do a Donald today, but I do know that by the time we come back next time, we will have a resolution one way or another.
And Mr. Beckwith, what's the state's position on that?
No objection, Your Honor, so long as time is excluded.
Okay, so we come back in 2 weeks, Mr. DeBrigida?
Sure.
Okay. So, Mr. McCune, I'm going to reset today's hearing out 2 weeks to January 20th. It's actually a Tuesday, 9:30 in the morning. That's the next time I'll see you. Between now and then, continue to stay in touch with Mr. DeBrigida. Madam Clerk, if you could note a Donald advisement may be necessary. Okay. And again, time is excluded. Mr. DeBrigida, anything else today on Mr. McCune's matter?
No, thank you.
Mr. Beckwith?
No, Your Honor.
Okay, that's the end of our morning calendar. Thank you.
Thank you.
Just call
Yeah, give me a call.
We can take them around the back.
And then
Or you can come through here. I'll be in there in just a
my
minute.
office is at 51st Avenue on the 101, just in North Phoenix, like right by. It's one exit west of the 17.
First Monday morning.
Yeah, it's very easy to get to. It's like literally right on off the freeway. There's like you can see the Sikh temple.
That's
It's
sort of what
actually I have a Glendale post office, but that area is Phoenix. But you know those Sikh temples that are right there, and then in front of that there's a bunch of offices. That's where I am. It's right off. It's really easy to get to.
Right.
Call me Wednesday morning.
Okay, we'll figure it out.
Yep. All right.
Thank you.
Thank you.
To get mail. Get all my junk mail that's been piling up for a week.
You wouldn't have received the White Wolf plea agreement, would you? It's not on today, so you probably wouldn't. Okay.
Also, yeah, that's, I think it's Kayla's. But, okay, so.
Yeah, it is.
Brooks, 2 active DUIs, 8 months, probation. That's the minimum, right? For 2 active DUIs?
Yeah.
Okay.
She's doing,
She's been trying.
court can accommodate us, we'd also like to proceed to sentencing.
Just take a look here.
There's no required jail. It's unsupervised probation. We reside out of county.
No objection from the state.
Ms. Leonard, do we have the ability to at least get me a term sheet this afternoon, or no? Do you know? Oh, Ms. Mansour? Oh, okay. Okay. We'll see where we're at. We may need to do the change of plea, set it aside, and then come back a little bit this afternoon. But Mr. Susser, do you have some time if you needed to do that? Or where do you need to be next? I suspect you don't have just an afternoon blank.
I do not, but I would rather, if I had to, spend the time up here and get it done today than come back a different day.
Okay, well, let's see how far we go. Okay. Miss Dedkin, can you tell me your full true name, ma'am?
I'm sorry?
Can you tell me your name?
Oh, Robin Michelle Detkin.
Okay, what's your date of birth?
11678.
Okay, and how far have you completed in school?
Some college.
So you read and understand English without difficulty?
Yes, Your Honor.
Have you had any drugs, alcohol, or medication of any type in the last 24 hours?
No.
Okay, I've been presented with a plea agreement. It indicates you're going to plead guilty to count 1 as amended, which is attempted unlawful flight from a law enforcement vehicle, a Class 6, non-dangerous, non-repetitive, undesignated offense from November 19th of 2021 in violation of ARS 28622.01 and 13-1001 and other statutes, and also amended count 2, driving under the influence, a Class 1 misdemeanor from that same date in violation of ARS 281381 and other statutes. Did you have a chance to go over this written plea agreement with Mr. Susser?
Yes, Your Honor.
Okay. And if I look on the final page of the agreement where it says defendant, is that your signature on page 6?
Yes, Your Honor.
Prior to signing it, did you have the opportunity to review and understand the entire agreement?
Yes, Your Honor.
Okay. And was Mr. Susser able to explain it to you and answer any questions that you might have had?
Yes, he did.
Okay. And has anyone forced you or threatened you in any way to get you to plead guilty today?
No.
Let me go over what the maximums are for these 2 offenses, then we'll talk about what you've agreed to. For a Class 6 felony, you could get up to 3 years probation, 1 year jail, 2 years prison, and a $150,000 fine. For a Class 1 misdemeanor, being a DUI, you could get up to 5 years probation, 6 months jail, and up to a $2,500 fine. Now, let me look on page 2 and on to page 3, what you've agreed to. As to count 1 amended, you'll be placed on probation for a period of 24 months. The offense will be treated as a Class 6 felony for all purposes until you successfully complete your probation. If you do that, it can be then designated a misdemeanor. As to count 2, and now I'm on page 3, you'll be placed again on probation for 24 months. It'll run concurrent. You'll serve 10 days in the Gila County Jail with all but 1 of those days suspended upon your successful completion of a drug or alcohol screening in any classes. You'll receive credit for the 1 day that you have served. You'll pay $750 to the cost of prosecution. You'll pay a $250 fine plus surcharges. You'll pay $500 to the Prison Construction and Operations Fund, $500 to the Public Safety Equipment Fund. Your conviction will be reported to the Department of Motor Vehicles, and you'll comply with any interlock device requirements as may be designated by the Department of Motor Vehicles. Is that your understanding of the agreement?
Yes, it is, Your Honor.
And as the trial judge, if I found that that agreement was inappropriate, I could reject it. If I did, I would give both you and the state an opportunity to withdraw. The original charges could then be reinstated, and you could go to trial on those charges. Ms. Dedkin, back in 2021, were you on probation or parole for any charges at that time?
No, I was not.
Okay, I'm going to read you the citizenship warning that I read to everyone. If you're not a citizen of the United States, pleading guilty or no contest to a crime may affect your immigration status. Admitting guilt may result in deportation even if the charge is later dismissed. Your plea or admission of guilt could result in deportation or removal, could prevent you from ever being able to get legal status in the United States, or could prevent you from becoming a U.S. citizen. Do you understand that once I accept your plea, you can't change your mind and withdraw unless it's necessary to correct a manifest injustice?
Understand. Thank you.
By pleading guilty, you give up certain constitutional rights. I'm sure Mr. Susser has discussed those with you. I'm going to go over them one more time. You're giving up your right to a jury trial at which you could not be convicted unless the jury unanimously found you guilty beyond a reasonable doubt. You're giving up the right to confront and cross-examine witnesses who would be called to testify against you, the right to have subpoenas issued for your witnesses so they could attend your trial and testify for you. You're giving up the right to present other evidence on your own behalf and the right to testify if you chose to. At trial, you would also have the right not to testify, and if you chose not to testify, your failure to testify could not be used against you. You're giving up the presumption that you're innocent until proven guilty beyond a reasonable doubt. If you were convicted at trial, the jury would have to unanimously find, beyond a reasonable doubt, the existence of one or more aggravating factors before you could be sentenced to an aggravated term in prison. By pleading guilty, the court, not a jury, would decide whether aggravating factors exist. And finally, you're giving up the right to a direct appeal. Do you understand all those rights?
I do, Your Honor.
Do you understand that by entering the plea agreement, you're not going to have a trial, so you're giving up those rights for this case?
I understand.
Do you wish to do that and move forward with the plea?
Yes, Your Honor.
And by pleading guilty, your only right of review of these proceedings would be to file a petition for post-conviction relief with this court. If that was denied, you could then ask the appellate courts of this state to review that denial, but there's no guarantee that they would take up that review. Okay. Ms. Dedkin, amended count 1 is attempted unlawful flight from a law enforcement vehicle. How do you plead to that charge?
Guilty.
And amended count 2 is driving under the influence, a class 1 misdemeanor. How do you plead to that charge?
Guilty.
Are you pleading guilty voluntarily and on your own?
Yes, Your Honor.
I'm going to ask Mr. Susser to give me a short summary of what happened, called a factual basis. After he does, I'll ask you if you agree with him. So, Mr. Susser?
On or about November 19, 2021, within the jurisdiction of the court, and I'll do both counts at the same time.
Thank you.
Knowing or having reason to know that she was being pursued by law enforcement, which had its emergency lights activated, the defendant attempted to flee by failing to yield, continuing to drive at a safer than reasonable speed, and eventually getting into a single vehicle crash. At the same time, location, incident, and concomitantly with count 1, the defendant was impaired at least to the slightest degree by alcohol previously consumed.
Okay. Is that correct, ma'am?
Yes, that's correct.
Mr. Beckwith, any additions or corrections?
No.
Okay. The court finds that the defendant's plea is knowingly, intelligently, and voluntarily made. There is a factual basis for it. The court accepts the plea and enters it of record. The court will defer acceptance of the terms of the plea agreement until sentencing. Ms. Mansour, can you just give me do you think you'll be ready after copies?
Yes.
Wow.
I think so.
Thank you.
Thank you.
Ms. Dedkin, I'm sure you've discussed this with Mr. Susser. Normally, I would put off sentencing for approximately 30 days. We'd get a full pre-sentence report from the probation staff. My understanding is you'd like to waive the 30-day requirement, waive the full report, and move forward with sentencing today. Is that correct?
That's correct.
Okay. And Mr. Susser, you believe that's in your client's best interest?
Most definitely, Your Honor.
And Mr. Beckwith, the state has no objection to that?
No objection, Your Honor.
Okay, so the court will move forward with sentencing. Let me just wait till our probation staff provides a cheat sheet for all of us.
Your Honor, probation, notice the plea does not say unsupervised probation, but we don't have a stance on whether it's unsupervised or
Okay.
supervised.
Okay. We will move, Madam Clerk, I will move forward with sentencing then. The court has previously obtained the defendant's name and date of birth. The court has previously accepted the plea. The court will now accept the terms of the plea agreement. It is the judgment of the court that the defendant is guilty of count 1 as amended, an attempted unlawful flight from a law enforcement vehicle, and count 2, amended, driving under the influence of class 1 misdemeanor. I'm looking at the cheat sheet that has been prepared by probation. Thank you for doing that, Ms. Mansour. I think the only thing additional I would add would be there is now a $20 court security fee that needs to be added on. But beyond that, the court is inclined to follow those recommendations. Yes?
I think I was missing the public safety one as well. That might be an old.
Oh, yes, it is.
The public safety.
So I do need to cross that. It's listed on there. I just need to write next to it, $500. Okay. Mr. Beckwith, would the state like to add anything?
No, Your Honor.
And Mr. Susser, I'll hear from you and or your client.
Thank you, Your Honor. I'll go first then, just to be brief. Certainly, I'd ask the court to follow the terms of the plea. Just so the court's aware, this was a very specifically negotiated resolution with the state. I appreciate their reasonableness in this one. Part of the justification was it had been more than 4 years since the date of violation. The case was originally filed in the Justice Court. The state later dismissed it and refiled it. The defendant had no prior criminal history that I am aware of, and she has had no subsequent criminal history since this happened. If she feels the need to speak to the court, I'll defer to her, but I'll mention it sounded like she was going through an extremely difficult couple of years that sort of culminated in this incident. It was never her intention to harm anyone or anything, frankly, other than herself. She's made tremendous changes in her life since this happened. She has essentially had stable employment for the better part of 5 years or more. She's in a very, very good place. There is no reason to believe she will ever trouble the criminal justice system again. So I'd ask the court just to sentence her as stipulated, no additional jail time. And the plea agreement did not specify supervised or unsupervised. In my experience, that's usually a nudge. Unsupervised is fine. And that's what I would ask the court to impose. She does live out of county. I don't know if for unsupervised probation you even need to do courtesy supervision. Okay. Then I would just leave it at that, and she'll certainly be successful and take care of the remainder of the terms quickly.
And Ms. Mansour, I probably should verify, unsupervised out of county, it's going to be a phone or check-in like that, so she can just do it through us even though she's out of county?
Yes.
Okay. Ms. Dedkin, would you like to add anything to that? You don't have to, but you can.
No, thank you.
Okay. And Ms. Dedkin, it sounds like, as I hear from Mr. Susser, the person who sits before me today is very different than the person who was charged on that November date 4 years ago. Okay. So the court will find 2 mitigators, which is her admission and substance abuse. Considering those, the court finds as to count 1 that probation is appropriate. It is the judgment of the court that imposition of sentence is suspended. The defendant will be placed on unsupervised probation for a period of 24 months that will date from today's date. As to count 2, again, the court finds that probation is appropriate. It is the judgment of the court that imposition of sentence is suspended. The defendant will be placed on unsupervised probation for 24 months, again, concurrent with the other probation. I'm going to go over some of the terms of your probation. Before you leave, we'll need you to sign for all of them. I'll order the following financial obligations: a $20 time payment fee, $20 probation assessment, the $13, $9, and $2 assessments. The mandatory fine of, let's see here, in the plea, I believe it was $250. And actually, let's see, so $250, and the surcharge on that is not going to be, not to do some, does anyone have a calculator or a cell phone that they can assist me? What's 78% of 250?
78% of 250?
Yes.
$195.
Okay. $195 surcharge. $750 to the cost of prosecution, $500 to the prison construction and operations fund, $500 to the public safety equipment fund, and a $20 court security fee. I'll order that you make monthly payments of at least $80 a month, beginning February 5th until paid in full. I'll order that you be sentenced to serve 10 days in the Gila County Jail with all but 9 suspended upon your successful completion of an alcohol or drug abuse screen and any treatment. I'll find that you have 1 day credit as of today. I'll formally order that you complete an alcohol or substance abuse screen and any recommended treatment as directed by probation at your own expense. Mr. Susser, has your client during the intervening 4 years done anything like that, or has she just taken other steps to change her life?
I think there was so much delay in between the original case and the refile that the whole case kind of went on a back burner.
Okay.
So I don't believe she's done that.
So you will need to do that, ma'am. With what Mr. Susser communicates to me, and I have no reason to doubt it, they'll do the screening and say you probably don't need any additional classes. I'll order that while on your probation, you not consume alcohol, not be in bars or liquor stores. I'll order that your conviction be reported to the Arizona Department of Motor Vehicles and that you comply with any ignition interlocked device requirements that they impose upon you. I have no idea what that's going to look like, given the dates of violation and those type of things, and whether you had to do that originally through the civil process or not. But you just have to comply with whatever they direct you to.
Yes.
I'm sure Mr. Susser can assist you with that. So for count 1, you'll be on probation for a Class 6 undesignated felony. If you violated your probation, even though it's unsupervised, you could be brought back in. The maximums that I talked about earlier: 3 years supervised probation, up to 1 year jail, 2 years prison, $150,000 fine could still be in play. The good news is if you complete everything, it can be designated a misdemeanor. With the misdemeanor, again, if you violate, you could get a total of 5 years probation, 6 months jail, and up to a $2,500 fine. You have the right to petition for post-conviction relief from the orders of this court and to have a lawyer represent you. If you cannot afford a lawyer, one would be appointed to you. If you cannot afford copies of the necessary records and transcripts, they would also be provided to you at no cost. If you want to petition for post-conviction relief, you need to do so within 90 days of today's date, or you lose the right to seek that relief. I'll order that all additional counts in this matter dismissed pursuant to the plea are hereby dismissed. Any bond is exonerated. Mr. Susser, for the purpose of the advisory, your client has no prior felonies?
None more.
Okay. A felony conviction, which is count 1 at this point, suspends your civil rights, the right to vote, serve as a juror, hold public office, and bear arms. As a first-time offender, upon completion of your probation, your right to vote, serve on a jury, or hold public office automatically is restored. Although these rights are automatically restored, you will need to re-register to vote. You can also file an application to set aside your judgment of conviction. Applications to restore civil rights can be obtained from the clerk of court at no cost and filed without a filing fee. Mr. Susser, anything additional in this matter?
I don't believe so, Your Honor. Thank you.
Mr. Beckwith?
No, Your Honor.
Ma'am, we'll need you to come up, sign for your review rights, give us some fingerprints, and also for your probation terms, even though they're unsupervised. And again, thank you, probation, for being willing to get that done.
You're welcome. Have a good one.
Thanks, probation.
You're welcome.
That's funny. I only didn't hear since I passed the bar. Yeah. 2 years ago? Yeah. 2 whole years. Yep. Yeah, so that's funny. But there's some people in our office who were working in Mojave County. Yeah. You practice something? Yeah. Oh man, different world.
Oh.
It's really fun.
Oh.
Greenwood.
Oh.
Grand.
Yeah.
They got one judge.
No, clerk, can you do an after hearing note
So,
when I'm
I heard
vacating the February 4th trial?
The divorce sales. So civil lawsuit because they don't care. They're like, we got 5
Yeah,
minutes.
February 4th, 2-4.
Civil and a couple criminals.
Dude, so I heard that Apache County doesn't do grand juries because they don't have enough people.
I believe that.
Yeah,
So,
so-
absolutely. So it's prelims. Everything's
Yeah.
paid justice.
Exactly.
Thanks, Mark.
Mr. Beckwith, Mr. Susser, I asked the clerk to do an after hearing note vacating the trial. It's
Oh,
in February. I failed to do that.
Okay.
Thank you, Your Honor.
And Mr. Beckwith, Ms. Ormond had it confused on her calendar where she's supposed to be today. She had the Gilmore matter in Globe, so she's over there, so she's going to be zooming in for us.
Okay. Yeah, makes sense. She's got a lot.
Let's see here. Marcus.
Who's
What's up?
who's his attorney?
Dean.
Mr. Donahue here? Why don't you come on up to the desk, sir? And is that Mr. Penna? Just have a seat right behind the microphone there. Mark, I just printed out an order in a juvenile case. If you could bring it to me, I'm going to sign it, and then I'll ask you to scan it and send it back to Veronica. This Thursday. Oh shoot, can't do that. Go back to, let's do Tuesday the 13th. put it on, there's a packet of stuff for Veronica on my desk. We'll do that because we're going to get it to her soon. Okay, good afternoon, Mr. McCarty. I think we're ready on the Donahue matter.
Yes, thank you.
Oh, is that?
Did you see?
Yeah, because that's just one of the ones. He already has 3 other cases. They just missed the one. They missed 93. He has 94, 95, 96 on the calendar. Okay. Good. Okay, next matter is, our matters are State versus Donahue, CR 2025, 361 and 365. We're here for a pretrial conference in the 361 matter, which is currently set on January 28th. This matter, the other matter is set for a status hearing today. I'll note Mr. Donahue is present, out of custody, represented by Mr. McCarty, who's joining us remotely today. Mr. Beckwith is here from the county attorney's office. I'll let counsel know, and Mr. Donahue, that earlier today I affirmed the red matter, which is a case that has priority. The arraignment is approximately 2 years earlier than this matter, so the court is going to need to reset the trial in this matter. Mr. McCarty, let me start with you. Are we still, from the defense perspective, still on a trial track in this matter? Okay, so Mr. McCarty, if I vacate the trial at this point and then just reset us in about 4 weeks for a trial setting conference, would you like that opportunity to make one last stab before we start doing a bunch of dates for trial?
Yes, Judge.
Okay. And you'd be willing to waive time to accomplish that?
Yes.
Okay, and Mr. Beckwith, on behalf of Ms. Evans, any objection to that?
No objection, Your Honor. I believe this is with Ms. Cheskis, though.
Oh, is it?
Yes.
And Mr. McCarty, does that sound right?
And
Okay.
she's agreed to hold the plea offer open until January 12th.
That's only 1 week.
Yeah.
Okay. Mr. McCarty, was it your understanding that the plea offer would be held open till the next hearing or just till the 12th?
I can communicate with her, keep it open.
Okay. So, Madam Clerk, first I'm going to vacate the trial and the status hearing that are set on January 28th. I'm going to reset a trial setting possible change of plea for February 2nd. I will utilize the 1:30 time slot here in Payson. So, sir, that's the next time I'm going to see you. February 2nd, 1:30, right here. Make sure between now and then you continue to stay in touch with Mr. McCarty. Sounds like there's some things happening in the background, and he needs to make sure that you can know about those ASAP. I'll find that time is excluded in both matters, Madam Clerk, and again, I'm vacating the January 28th trial date based on the congestion of the court's calendar. Okay, Mr. McCarty, anything else then on the Donahue matter? Mr. Beckwith, anything else on Donahue?
No, Your Honor.
Okay, that'll be all today, sir. Thank you.
February 2nd, 1:30.
February 2nd, 1:30. You got it.
Okay, thank you.
Okay. Mr. Penna, can we have Mr. Penna up to the table? Okay, next matters are State versus Penna, CR 2024-19 and 2025-223. See, is there just 2 cases? I only had 1 originally, but I think there are 2 on the calendar. Okay, so I've called both of those. I'll note the defendant is here in custody in person. Mr. McCarty is appearing remotely. Mr. Beckwith is here from the county attorney's office. And Mr. McCarty, I think this is one where it was continued from 1 week. Can you give me an update on where we stand today?
Yes, Judge.
Okay, and Mr. Beckwith, this is your matter?
Correct. And the deviation request I couldn't get permission for, so I think we just need to set it for
Okay.
trial.
So, Mr. Penna, I'm going to go ahead and get the first of your matters set for a jury trial. And Mr. Beckwith, you'd like to try the 519 case first, since it's the older of the two?
Correct, Your Honor. Do we need to do a Donald advisement?
We probably do.
Okay.
Okay, let me just see here. Okay. And Mr. McCarty, do you have a copy of what the current plea offer is?
I have a copy.
Okay. Okay. And Mr. Penna, we're going to go through a process called the Donald advisement. We're just going to, Mr. Penna, purpose is not to pressure you in any way. It's just to make sure everybody has the same information. We'll talk about what the plea offer is. We'll talk about what can happen at trial. Just verify at this point you want to get it set for trial, knowing that the plea offer expires today. Okay. And so, Mr. McCarty, if you can summarize what the current plea offer is. Okay. I'm going to ask Mr. Beckwith to summarize what's contained in the plea.
Your Honor.
Pull the microphone over just at least so it's pointing towards you. Thank you.
Your Honor, the plea offers to count 1, possession of a narcotic drug, class 4 felony, and to count 2, possession of drug paraphernalia, class 6 felony.
519 matter? Because there's 2 cases, right?
Yes, these are both 519.
Okay.
So the plea actually dismisses the other case.
Okay.
So with 1 historical prior felony conviction, the state offers the minimum term for a Category 2 sentencing. So it's 3 years in the Arizona Department of Corrections. As to count 2, the drug paraphernalia, it would be a supervised probation for a period of 3 years to run consecutive to the prison sentence.
And the state alleges that the defendant has at least 2 prior drug offenses?
We do.
Okay. So, Mr. McCarty, does that sound correct? 3 years DOC followed by 3 years probation? Okay. And Mr. Penna, you understand that that's what the current plea offer is?
Yes, I do, Your Honor.
Okay. And then, Mr. Penna, we're going to talk about what can happen if you go to trial on these matters. The first thing that can happen is if you go to trial, jury could find you not guilty on both of them. If you do, you go home, you're all done. So we're going to talk about each case individually. And Mr. Beckwith, the state's alleged at least 2 drug priors, and how many prior historical felonies has the state alleged?
Historical?
Yes.
2.
Okay, so 2. Okay, so he becomes a Category 3. The state believes if he goes to trial.
Correct.
Okay, so Mr. Penna, again, if you go to trial and you're found not guilty, obviously you go home. You're all done. If you are found guilty, and we're going to talk about first the 519 matter, the drug case. If you're found guilty of a Class 4 felony without any priors, you're eligible for probation. You could get up to 3.75 years in prison, up to 1 year jail. If the state alleges and proves a prior felony, you become mandatory prison. The range of sentence goes from 2.25 years up to 7.5 years. If the state proves that you have 2 prior felonies, the range of sentence goes from 6 years up to 15 years. As to count 2 on the paraphernalia, again, without any priors, you're probation eligible. You could get 3 years probation, 1 year jail, 2 years prison. If the state proves that you have a historical felony prior, the range of sentence is between 3/4 year to 2.75 years. If they prove you have 2 historical priors, the range goes from 2.25 to 5.75 years in prison. Those terms I just went over could be at the same time, or they could be stacked on top of each other. Do you understand that?
Yes, I do, Your Honor.
Okay, and then in the second case, let's see here. Again, if you're found not guilty, you go home, you're done. The second case has 1 Class 6 felony and 2 Class 5 felonies. For the Class 6 felonies, again, just like the paraphernalia, without any priors, you're eligible for probation. You could get 1 year jail, 2 years prison, a $150,000 fine. With 1 prior, the range of sentence is 0.75 years to 2.75 years. With 2 priors, the range is 2.25 years to 5.75 years. They could run concurrent or consecutive to the other cases. And then the Class 5 felonies, without any priors, the range of sentence is between up to 3 years probation, 1 year jail, 2.5 years prison. If there's a prior approved, it becomes mandatory prison, 1 to 3.75 years with 1 prior, 3 to 7.5 years with 2 priors. That's for each count 2 and count 3. You understand that?
Yes, I do, Your Honor.
Okay. And with all that information, and after discussing it with Mr. McCarty, you do not wish to take the plea offer. You wish to get these matters set for trial. Is that correct?
Yes, it is, Your Honor.
Okay. Mr. McCarty, anything else in the nature of a Donald advisements? Mr. Beckwith, anything? Go ahead, Mr. McCarty. Okay. Mr. Beckwith, anything else in the nature of a Donald advisements?
No, Your Honor.
Okay, so first I'm going to get the 519 matter set for trial. And Mr. Beckwith, 2 days, 8 jurors, or what are you thinking for as far as days of jurors?
2 days, 8 jurors.
Mr. McCarty, does that sound correct? Okay. And counsel, is there, as soon as I can find a date, are you available, or is there some lag time we'll need for drug tests, etc.? Testing. Mr. Beckwith?
I have nothing, Your Honor.
You ready to go as soon
yeah.
as it's ready?
Yeah.
Mr. McCarty, I think on March 18th, I do not have any in custody, so Mr. Penna would be first. Would you like to look at March 18th? Okay. Okay, how about March 11th? Okay, Mr. Beckwith, March 11th?
Is there any chance we could do April? I apologize.
Mr. McCarty, if we go out to Mr. Beckwith has requested April 1st, I have no in custodies. Would that work for you, Mr. McCarty? And April 1st works for you, Mr. Beckwith?
Yes, thank you, Your Honor.
So, Madam Clerk, I'm going to set the 519 matter for jury trial April 1st. That'll be here in Payson. We'll begin jury selection at 9. I'll meet with counsel at 8:30. We'll plan on 2 days and 8 jurors. I'm going to set a final pretrial conference in the case. Let's see here. I'm going to set that for March 16th. Okay. Okay, then I'm going to set that on March 9th. That'll be on my Globe calendar. I'll set that at 1:45 in the afternoon. I will also set a trial readiness notice hearing for March 3rd at 1:30 in the afternoon. That will be on my Globe calendar. If trial readiness notices are filed, that will be vacated. So all those hearings, Madam Clerk, are in the 519 matter. I'll set a status hearing in the 223 on both March 9th and April 1st to coincide with the other hearings. Okay, and I'll order that as on the March 9th date, that will be a virtual appearance unless otherwise requested.
Excuse me, Your Honor?
Yes, sir.
I have a question. So, besides this, I have the DOC hold. I'm going to stay here in the county until I finish this, correct?
Mr. McCarty, your client was asking about whether he's going to remain here in Gila County or whether he's going to go back to DOC. I
preferred if I could stay here in the county.
Okay.
So I can get it.
And he's saying he would prefer to stay here, Mr. McCarty. Do you have any objection if I direct that your client remain here in Gila County pending that next date? Okay. So I'll order that the defendant remain in Gila County custody pending that next date, which is March 9th. So you'll remain here in Gila County, sir.
Okay.
Okay, so March 9th in Globe, the defendant appearing virtually. April 1st here in Payson for jury trial. That'll be an in-person. Mr. McCarty, anything else on Mr. Penna today? Mr. Beckwith?
No, Your Honor.
Okay, that'll be all today. Thank you, officer. Donahue.
I figured that gives us more time for testing or whatever.
Let's see here.
Yeah.
Ms. Trango, are you here?
I started thinking.
Come on up, Ms. Trango. next matter is State versus Tarango, CR 2025-469. I'll note Ms. Tarango is present, out of custody. Our attorney, Mr. McCarty, is appearing remotely this afternoon. Mr. Beckwith is here from the county attorney's office. We're here for a trial setting, possible change of plea. Mr. McCarty, can you give me an update on where we stand from your client's perspective? Okay, so first, let's, Mr. Beckwith, can you give Mr. McCarty information about disclosure?
Yes, Your Honor. Looks like it was sent on October 29th.
So, Mr. McCarty, looks like it was sent to, was that the Office of Indigent Legal Services on October 29th?
Yes.
Okay, so Mr. McCarty, looks like October 29th is when it was sent to Office of Indigent Legal Services. Mr. Okay. Mr. Beckwith, Mr. Beckwith, who's this assigned to within your office?
This is with Mike Van Auker.
Okay.
Mr. Van Auker.
Okay. This is Mr. Van Auker's matter. And Mr. Beckwith, there was a plea offer that sounds like it's been extended that was good till the next status hearing. Was that Mr. Van Auker anticipating that I'd set this for trial today and then set an intermediate status hearing?
I have nothing to indicate otherwise,
Okay.
so I believe so.
And Mr. McCarty, what I'm inclined to do is set this off for 4 weeks so that you can get that disclosure, speak with Ms. Tarango, and go from there. Would you like me to do that? Yeah, I think
Yes.
Mr. Beckwith is saying he's what the court typically, when you hear it's open till the status, that would be if I set the matter for trial, I'd set a pretrial in the status, and that's when that status would be. Mr. Beckwith does not have any difference from that, so if I just set this out for a new trial setting, possible change of plea, it sounds like it'll remain open till that day at least.
If I may, Your Honor.
Yeah, Mr. Beckwith?
Mr. Van Auker said a plea offer is available and it's okay to continue, so I believe
Okay.
it will remain open.
Okay. So, Mr. McCarty, February 2nd, will that work for you? Okay. So, Madam Clerk, I'll set this for continued trial setting, possible change of plea, February 2nd at 1:45 in the afternoon. Mr. McCarty, do you have contact information for Ms. Tarango so you can get her the offer that's been extended? Okay. And Ms. Tarango, can you provide your phone number for Mr. McCarty?
It's 928-313-3758.
Okay. And is that, do you need an email or will that be sufficient, Mr. McCarty? So sometime later this afternoon, you'll get a call from Mr. McCarty. He can discuss the matter. Your next hearing, ma'am, February 2nd at 1:45 in the afternoon. That's when I'll see you again. Time is excluded between now and then. If you fail to appear for that hearing, a warrant could issue for your arrest, so make sure you're present.
Okay.
Okay, that's all today, ma'am. Thank you.
Thanks.
And Mr. Adler, if you'd like to make your way up. Okay, we do have Rogers.
Nope. Yes. Nope. Yes.
Schroeder. Okay, and Mr. Rogers, who's Mr. Okay, Mr. Rogers, you have Mr. Dean, so we're waiting for him to join us. And then, I have two Mr. Rogers this afternoon. It looks like you're both here. So I'll make sure I use first names when I call your cases. You're both nodding at me like you're the one, and you are. And then Ms. Schroeder. My understanding is you've retained Mr. Ramos. Okay, so we'll be waiting for Mr. Ramos to join us before I call your name, ma'am. I just want you to know we haven't forgot about you. Okay. So, Mr. McCarty, we're going to go to the Adler matter next. As soon as I can pull it up. 2, 4. Next matter is State versus Adler, CR 2022-223. I'll note that Mr. Adler is present out of custody, represented by Mr. McCarty. Mr. Beckwith is here from the County Attorney's Office. We're here for a pretrial conference today. This matter is currently set for trial on February 4th. It does not appear that I've seen trial readiness notices from either party. So let me start with you, Mr. McCarty. I think at this point, this is the first, it has priority on my calendar. There may be some courtroom space issues because Judge Chambers has a case here, and I also think I may have a juvenile calendar, but as of right now, this is first. Can you give me an update, Mr. McCarty? Okay, and Mr. Beckwith, as far as you know, is Miss Evans going to be ready for trial?
Yes, Your Honor.
Okay, so Madam Clerk, as of today, I'm going to affirm the trial. I'm going to order that a jury be summoned, that digital evidence, the portal be opened. Madam Clerk, I'll note, I believe this is a county-wide jury given the date of violation. I'm also going to set a review of jury questionnaires. Mr. McCarty, you've indicated, I think you said you were out of the office or unavailable on February 2nd. Can you zoom in that day for a review of jury questionnaires? Oh, I'm thinking it was a March date that you were unavailable. Someone else that was February. Okay. So, Madam Clerk, I'll set a review of jury questionnaires for February 2nd at 4 o'clock. 2-2-4. Mr. Adler, that's the next time I'll see you, February 2nd at 4 o'clock.
Okay.
Okay, we'll be reviewing those. Counsel, I'll get working on draft language for the jury questionnaires that will hopefully go out to you in the next several days. We still have a little bit of time on that one. Let me just see here, jury. Okay. Mr. Beckwith, anything additional from the state?
No, Your Honor.
Mr. McCarty, anything else on the Adler matter besides what I've done? Okay, so Mr. Adler, I'll see you on that date. And as I've told you before, trial's February 4th. If you fail to appear, the trial could go forward in your absence. You've been here. I just tell that to everybody.
February 4th. February 4th.
February 4th is when the jury trial is. We'll begin picking our jury at 9. I'll meet with the attorneys at 8:30.
Should I be here for picking a jury too, or no?
Pardon?
For the jury?
I'll let you. Talk to Mr. McCarty.
Okay.
I'm
Thank
sure
you.
he's going to want you here probably at 8:30 on the 4th.
Okay. Thank you.
Talk to him. Okay.
Have a good day.
Okay. Thank you, sir. Okay. Let's see. And let's see. Mr. McCarty, you have the Mannery matter. Okay, and is Miss Mannery here?
Yes.
Okay, why don't you come on up? Okay, and then after we do this one, then we'll slide over to Miss Ormond's matters. Yeah, I've seen hers as well. So we have a flurry of emails that my JA, thank you for reaching out to Veronica, and she promptly was emailing us. So, okay, let me go to, okay. Next matters will be State versus Mannery, CR 2025, 578, 580, and 584. Each of these matters are set for arraignment this afternoon. I'll note that Ms. Mannery is present out of custody. Mr. McCarty, who was appointed at grand jury returns, is appearing remotely. Mr. McCarty, you represent Ms. Mannery on another matter. Have you had an opportunity to speak with her at all on these matters? Okay. Okay, so Ms. Mannery, what I'm going to do is I'm going to summarize what's contained in each of these matters, and then we'll move from there. As I've told you before, you have the right to remain silent. You also have the right to representation by counsel, and we've already appointed that. The 578 matter alleges the indictment was returned on December 16th. It alleges count 1, possession of dangerous drugs from July 12th of 2024, methamphetamine. Count 2 alleges possession of drug paraphernalia involving methamphetamine from that same date. The 580 matter, the indictment was again returned on December 16th. It alleges count 1, possession of drug paraphernalia, class 6 felony from November 12th of 2024, a class 6 felony. And finally, the third matter, the 584, returned on December 16th, alleges count 1, possession of a dangerous drug from April 14th of 2024, methamphetamine. Count 2, possession of a narcotic drug from the same date, a class 4 felony, fentanyl. Count 3, possession of drug paraphernalia from the same day, a class 6 felony. And count 4, forgery, a class 4 felony, alleged to knowingly possess a forged instrument. Mr. McCarty, with that summary, are you willing to waive a full formal reading on all 3 of these matters? Okay. So I'm going to enter your not guilty plea of record, ma'am. A denial is to any sentence-enhancing allegations. Mr. McCarty, what I'm inclined to do is set all of these for a case management conference on January 20th, which is, I think, when her other matter is next set. Will that work for you?
Yes, sir.
Okay. And Mr. Beckwith, these are your matters. Any objection to that?
No objection, Your Honor.
So, Madam Clerk, I'll set these 3 matters for a case management conference. That will be on January 20th. That's here in Payson. Mr. McCarty, I don't think the minute entry from our last hearing has come through. Do you recall the time that she's set on the 20th? Okay, Mr. Beckwith, do you happen to have it in your file notes?
One moment, Your Honor.
That is the 21st. Look at the first one.
It's the 20th. It's Monday the 20th, or Tuesday the 20th.
Okay.
But you thought it was 1:30?
I thought it was the 21st.
It's the 20th at 2:15.
So 2:15, Madam Clerk, is the time for that. So the 20th, which is the Tuesday after the Monday holiday,
Okay.
at 2:15. Okay, do you still have one of Mr. McCarty's business cards?
I don't.
Okay, we'll get you one of those in just a moment. Okay, Mr. McCarty, anything else on Miss Mannery today? Okay, Mr. Beckwith, anything else on Miss Mannery?
No, Your Honor.
So, ma'am, make sure you circle back to Mr. McCarty. I don't know how soon he's going to have any paperwork on these new cases, but make sure you do that. We'll see you on the 20th.
Okay, thank you.
Thank you. Okay, let's see here. Mr. Dean, are you with us? And you're on mute, Mr. Dean. Okay, and Mr. Dean, I have 2 different Rogers this afternoon. You're on Gary Don Rogers, is that correct? Okay, first. So Gary Rogers, if you'd like to make your way up front. Mr. Dean, I don't see anything. Did you send that to Veronica, or who did you send that to? Oh, you know what? No, maybe I do see it. Oh, I do see it now. Okay. Let me see here. Let me see if I can print that, Mark.
It's printed, Your Honor.
Oh, you have it?
We have it, we just don't have Mr. Rogers' signature.
Okay. And so, so the state signed it, and do we have an ink signature today?
Yes.
Okay, so Mr. Dean, you're asking that we provide this to Mr. Rogers?
Yes.
Okay. Okay.
What? Sorry.
Okay. So what he's signing it right now. I'm going to have Mark make his copies. After the copies are made, then I'll call the case and we'll go through the colloquy. And Mr. Dean, while we're waiting, are you going to be here in Payson anytime in the next 4 to 6 weeks where we could set sentencing? Okay. That would be in Globe. Yeah. His calendar's a lot simpler. He's always in Globe. He doesn't, at least for his adults. His juvies, he goes back and forth, but. Does Mr. Rogers, you live here in Payson, sir?
Yes.
Okay. What time are you with Judge Chambers on the 2nd? Okay. Well, that's pretty far out. I prefer not to do that. What time are you with Judge Chambers on February 2nd? Okay. Would you be available maybe to hit us here in Payson at 10:30 and then make the triangle run from Phoenix to Payson to Globe to Phoenix? Okay. And so February 17th?
It might be the updated one.
Yes, because Monday's a holiday. Okay, so we'll work on that. We'll find a time in just a moment. That day's wide open. I'm going to be asking you to suggest a time if you want to. Okay, so Madam Clerk, we'll go on the record in State versus Gary Don Rogers, CR 2025, 93, 94, and 95. I'll note Mr. Rogers is present out of custody here in person. His attorney, Mr. Dean, is appearing remotely. Mr. Beckwith from the County Attorney's Office is present. I've been presented with a plea agreement, and just to put a little bit on the record, Mr. Dean's signature on the plea agreement is a copy as he signed it and then emailed it to my JA. Mr. Rogers has signed the plea here in court today along with Mr. Beckwith. Mr. Rogers, are you willing to move forward with this change of plea with Mr. Dean remote today?
Yes.
Okay. If at any time you need to speak with Mr. Dean, we can't easily do it, but we'll try to figure out a way where you can talk to him in private if you have a question about what we're doing. Okay.
All right.
So first, can you tell me your full true name?
Gary Don Rogers.
What's your date of birth?
August 25th, 1981.
Okay. And how far have you completed in school?
GED.
So you read and understand English without difficulty?
Yeah.
Have you had any drugs, alcohol, or medication of any type in the last 24 hours?
Just my mental health medication.
Can I ask you to pull the microphone a little closer to you? That way you can keep sitting up.
No, just Abilify.
Okay. And is there anything about taking that medication that causes you difficulty understanding me right now?
No.
Okay. I've been presented with the plea agreement. It indicates that in the 93 matter, you're going to plead guilty to theft of means of transportation, a Class 5 felony, from January 1st of 2025 in violation of ARS 13-1803A1 and other statutes. In the 94 matter, you're going to plead guilty to count 4, aggravated harassment, domestic violence, a Class 5 felony, non-dangerous, non-repetitive felony from August 3rd of 2021. Okay, and then it looks like the other matter will be dismissed in its entirety along with all of the other charges in these 2 cases. Okay, did you have a chance to go over this written plea agreement with Mr. Dean?
Yes, I did.
And it sounds like you and he had a somewhat extensive telephone conversation about it. Is that correct? Okay, and if I look on, you have a copy of the plea there. If I look on page 7, is that your signature on where it says defendant?
Yes, it is.
And before signing it, did you have the opportunity to review and understand the agreements?
Yes.
And was Mr. Dean able to explain it to you and answer any questions that you might have had?
Yes, he was.
Has anyone promised you anything that's not in the agreement?
No.
Has anyone forced you or threatened you in any way to get you to sign this agreement?
No.
Let me go over what the maximums are for a Class 5 felony, which is what each of these are. After that, then we'll talk about specifically what you've agreed to. Class 5 felony, you could get up to 3 years probation, 1 year jail as a term of probation, 2.5 years in prison, and up to a $150,000 fine. Do you understand those maximums?
Yes.
Now, I'm going to look on page 3 of the agreements. It says that you'll pay restitution and have no unwanted contact with any victims in each of these 3 matters, whether you're pleading to a specific charge or not. In the 93 matter, you'll be placed on supervised probation for 2 years without the possibility of early termination. So you're going to have to do the whole 24 months. In the 94 matter, you're going to be placed on supervised probation for 3 years that'll run after you finish the 2 years. So basically it's 5 years probation. You'll pay $750 to the cost of prosecution. The state will have 90 days after sentencing to submit a restitution request. You'll pay $50 to the Domestic Violence Shelter Fund, $50 to the Address Confidentiality Program. You'll complete a domestic violence treatment program at your own expense. You'll complete the Contentious Relationships Program approved by probation. And in exchange, in the 93 cases, all the remaining charges and allegations are dismissed. In the 94, all the remaining charges and allegations are dismissed. And in the 95 case, it's dismissed in its entirety. Is that your understanding of the agreement?
Yes.
And if I, as the trial judge, determined that the agreement we just went over was inappropriate, I have the ability to reject that. If I did, I would give both you and the state an opportunity to withdraw, and then the original charges would then be reinstated. Do you understand that?
Yes.
Okay. Are you currently on probation or parole, Mr. Rogers?
No.
Okay, I'm going to read you the citizenship warning that I read to everyone. If you're not a citizen of the United States, pleading guilty or no contest to a crime may affect your immigration status. Admitting guilt may result in deportation, even if the charge is later dismissed. Your plea or admission of guilt could result in deportation or removal, could prevent you from ever being able to get legal status in the United States, or could prevent you from becoming a U.S. citizen. I'm also going to read you the domestic violence advisory. If you're convicted of a charge that involves the use or attempted use of physical force or the threatened use of a deadly weapon, you would be prohibited by federal law from possessing a firearm or ammunition. After this case is over, you will have been convicted of a domestic violence offense as defined in ARS 133601A. If you're convicted of a second domestic violence offense, even if it normally would have been a misdemeanor, you could be placed on supervised probation with a term of jail as a term of probation. A third or subsequent charge, again, even if it normally would be a misdemeanor, could be filed as a felony, and a conviction for that offense could result in a term of incarceration. Mr. Rogers, do you understand that once I accept your plea, you can't change your mind and withdraw unless it's necessary to correct a manifest injustice?
Yes, I understand.
And by pleading guilty, you give up certain constitutional rights. You're giving up your right to a jury trial in each of these cases, at which you cannot be convicted unless the jury unanimously found you guilty beyond a reasonable doubt. You're giving up the right to confront and cross-examine witnesses who would testify against you, the right to have subpoenas issued for your witnesses so they could attend your trial and testify on your behalf. You're giving up the right to present other evidence on your own behalf and the right to testify if you chose to. At trial, you would also have the right not to testify. If you chose not to, your failure to testify could not be used against you. You're giving up the presumption that you're innocent until proven guilty beyond a reasonable doubt. If you are convicted at trial, the jury would have to unanimously find beyond a reasonable doubt the existence of one or more aggravating factors before you could be sentenced to an aggravated term in the Department of Corrections. By pleading guilty, the court, not a jury, would decide whether aggravating factors exist. And finally, you're giving up your right to a direct appeal. Do you understand these rights, sir?
Yes.
And do you understand that by entering a plea of guilty, you're not going to have a trial in any of these 3 cases? Do you understand that?
Yes.
And do you wish to give up the rights and move forward with a plea agreement?
Yes, I do.
And by pleading guilty, your only right of review of these proceedings would be to file a petition for post-conviction relief with this court. If that's denied, you could then ask the appellate courts of this state to review that denial, but such review may or may not be granted. Mr. Rogers, count 1 in the 93 matter is unlawful use of means of transportation from January 1st of 2025. How do you plead to that charge?
Guilty.
And count 4 of the 94 matter is aggravated harassment, domestic violence, a class 5, non-dangerous, non-repetitive felony from August 3rd of 2021. How do you plead to that charge?
Guilty.
And are you pleading guilty voluntarily and on your own?
Yes.
I'm going to ask Mr. Dean to go through these one at a time, give me a short summary of what occurred. After he does, I'll ask if you concur. Mr. Dean, could you give a factual basis first for the unlawful use of means of transportation matter? And Mr. Is that correct, Mr. Rogers?
Yes.
Mr. Beckwith, any additions or corrections?
No, Your Honor.
And have all victims' rights been complied with?
Yes, Your Honor.
And then Mr. Dean, if you could provide a factual basis for the aggravated harassments. Mr. Beckwith, should that date be August 5th, not August 3rd?
Yeah, it's supposed to say August 5th.
Okay, so Mr. Dean, it is August 5th. I'm going to change that on the plea agreement. So there was a valid order of protection, and then he violated that. Is that correct? Is that correct, Mr. Rogers?
Yes.
And Mr. Beckwith, any additions or corrections there?
No, Your Honor.
And Mr. Dean, that was here in Gila County. Court finds that the defendant's plea is knowingly, intelligently, and voluntarily made. There is a factual basis for it. The court accepts the plea and enters it of record. The court defers acceptance of the terms of the plea agreement until sentencing. I'm going to go out to February 7th for sentencing, 17th, excuse me, February 17th. Mr. Dean, do you have a time of day you prefer on the 17th? Okay, I have 1:45 available, so I'll set this for sentencing. February 17th at 1:45 in the afternoon. I'll order that a pre-sentence report be prepared. Mr. Rogers, before you leave today, one of our probation staffers is going to provide you with a packet to fill out. If you can, I'd like you to try to fill that out today, just in the lobby, and make sure you return that to them before they leave. If you have any questions about that, I'm sure you can reach out to Mr. Dean and he can assist you with that.
Okay.
If you fail to appear for sentencing, the guarantee of probation you have goes away, so make sure you're present. Mr. Dean, anything else on the Rogers matters? Okay, that'll be all today. Thank you, sir.
All right, thank you. Oh, Your Honor?
Yes.
I have one question.
Okay.
Can I start the domestic violence classes before sentencing?
You can.
Okay.
They need to be probation approved, though. So Ms.
Okay.
Mansour can probably make sure you're not just spinning wheels doing things that aren't going to count.
Okay.
Thank you.
All right, thank you, sir. Yes. I did not bring it today, but I can get it today.
Ms. Mansour. So you can probably drop that off at the office if you don't have it today. Okay,
Okay.
thank you. Thank you, Mr. Dean.
Thank you, Your Honor.
Let's see. Do we have Mr. Ramos? We lost Mr. Ramos. Ms. Schroeder, if you want to make your way up front.
Thank you.
If you want to have a seat just right there behind the microphone, ma'am. Okay. Next matter is State versus Schroeder, CR 2025-486. I'll note that Ms. Schroeder is present out of custody. Her attorney, Mr. Ramos, was on the line earlier. He just substituted in. I've been informed by Mr. McCarty, who's on the line, that he's going to be standing in at least for today's hearing. I'll note that Mr. Beckwith is here from the county attorney's office. Mr. McCarty, let me start with you on behalf of Mr. Ramos. Where do we stand today? Okay, and Mr. Beckwith, is there an expiration date on that offer?
Your Honor, it's March 2nd.
Okay, 2nd. Okay. Given that Mr. Ramos is coming on board, I'm inclined just to set this for a trial setting, possible change of plea, potentially on March, probably February 17th. Mr. McCarty, do you know if Ms. Schroeder, does she live here in Payson, or is Globe or Payson either way easier for her? Ma'am, would you prefer to be here or in Globe, or do you care?
Preferably here, but I live in Mesa, but here's
Okay,
easier.
because it's easier to line up. Mr. Ramos is he's typically in Globe more than he's here. So what part of Mesa are you in? Because a lot of times from Mesa, it's about the same. You just go east instead of north. Because Globe from Mesa is only about an hour, and so it's just same thing. Okay, so if I set it in Globe, that's not a problem, ma'am. It's going to be a lot easier for me to find a date with Mr. Ramos where he's there in person, so we don't have this kind of issue.
Okay.
Okay, let me just take a look. 2:30. I'm looking at February 9th. Mr. Beckwith, any issue with setting it in Globe on February 9th?
No, Your Honor.
Okay, and Mr. McCarty, as far as you know, that'll work for Mr. Ramos? Okay, so ma'am, I'm going to set your next hearing February 9th. It's going to be in Globe, though, not here. That's going to be at 2:30 in the afternoon. Between now and then, stay in touch with Mr. Ramos. Sounds like he's going to get paperwork. He has a new plea offer that's an option for you. We'll see where we're at.
Okay.
If the case isn't resolved on that day, I'll probably go ahead and get it on my trial calendar. That doesn't mean there's no pretrial resolution possible, but we just want to make sure we keep it moving. Okay, time will be deemed excluded as it is for the defendant's benefit, so she can meet with counsel. Mr. McCarty, anything else today on behalf of Mr. Ramos? Mr. McCarty, I'm sorry, Mr. Beckwith, anything else on the Schroeder matter?
No, Your Honor.
Okay, you're all done today, ma'am. I'll see you in Globe on that day. Okay, and Ms. Ormond, we're going to go to your matters next. I'm going to do, just so you know, we're going to do the Johnson matter, and then we'll do Clark, and then we'll do Glenn Rogers. So, Mr. Johnson, can you just have a seat up there? Are you guys doing okay? Or need a break? Okay, I'm just going to push a little bit. See where we're at. If you need to change your mind, let me know. Yeah, Mr. Deck. Okay, thank you, Mr. Deck. Okay, next matter is State versus Johnson, CR 2025-219. I'll note that Ms. Ormond is appearing remotely. Mr. Johnson is here in the courtroom. Mr. Beckwith is here from the county attorney's office. Mr. Johnson's currently in custody. And Mr. Deck, his probation officer, is appearing remotely as well. Ms. Ormond, can you give me an update on where we stand on this probation matter? Okay. Okay. Hold on just a moment, and I will find us a date. Okay. And Mr. Beckwith, 45 minutes, should that be sufficient, you think?
Yes, Your Honor.
Okay, and Ms. Ormond, do you think 45 minutes is sufficient time? Okay. Let's see here. And Ms. Ormond, I'd like to put this, well, either I'm going to put it in Payson or allow Mr. Deck to appear remotely. Do you have any objection if Mr. Deck, Mr. Beckwith, is Mr. Deck going to be the state's primary witness?
Yes.
Do you have any objection if Mr. Deck appears remotely for the hearing? And so if I put this on January 26th in 3 weeks, would that work for you? On my globe calendar? Okay, so Madam Clerk, I'm going to set this for an evidentiary hearing on the PTR. January 26th on my globe calendar. I'll set that at 2:45, and I'll set aside 45 minutes for that hearing. If you can note that Mr. Deck can appear remote. Mr. Deck, are you available on that date? Okay. And Mr. Deck, you have the option, if you choose to, and it's agreeable to the prosecutor, to appear remotely on that hearing. I'll order that the defendant be personally present in court for that hearing. Okay. And so with that, Ms. Ormond, anything else on Mr. Johnson today? Mr. Beckwith, anything else on Johnson?
No, Your Honor.
Okay. I'll see you on that date, sir. Thank you.
Thank you, sir.
And Mr. Clark, if you'd like to make your way up front. Next matters are State versus Clark, CR 2021-175 and 283. I'll note Mr. Clark is present out of custody. Ms. Ormond, his attorney, is appearing remotely. We have Mr. Deck from the probation staff joining us. Also, we have Mr. Beckwith from the county attorney's office. We'll just take a look here. Looks like we're here for a status hearing today. Although the minute entry from our last hearing doesn't note it, it appears that there was an arraignment at the last hearing. Ms. Ormond, can you give me an update on where we stand for Mr. Clark's matters? January 20th, which is 2 weeks from tomorrow, will that work for you? Okay, Mr. Beckwith, any objection to that?
No objection.
Madam Clerk, I'll set a continued status January 20th at 3 o'clock in the afternoon here in Payson. Time will be deemed excluded. So, Mr. Clark, that's the next time I'll see you. Do you have Ms. Ormond's contact information?
Yes, Your Honor.
Okay, it sounds like with the holidays and things, connection didn't happen. We want to make sure you have good opportunity to meet with her before you start making decisions.
Thank you, Your Honor.
Okay, I'll see you back on the 20th, sir.
Yes, sir.
Thank you. 3 o'clock. Okay. And Mr. Rogers, if you'd like to make your way forward. Next matter is State versus Glenn Douglas Rogers. CR 2020-144. I'll note Mr. Rogers is present out of custody. Ms. Ormond is appearing remotely. Mr. Deck, Mr. Rogers' probation officer, is appearing remotely this afternoon. And Mr. Beckwith is here from the county attorney's office. We're here for disposition today. Ms. Ormond, is your client prepared to proceed with disposition today? Okay. And Mr. Rogers, can you tell me your full true name, sir?
Glenn Douglas Rogers.
What's your date of birth?
8/3/84.
Based on the court's prior finding, is the judgment of the court that you violated the terms of probation in this matter. You were on probation for possession of a narcotic drug, heroin, with a date of violation of January 16th of 2020. I've reviewed the pre-sentence update report that was prepared by Mr. Deck. Mr. Deck is recommending a unsuccessful termination, as this is a matter that's subject to Prop 200. Given that information, the court is inclined to proceed in that fashion. Mr. Beckwith, would the state like to be heard?
No, Your Honor.
And Ms. Ormond, would you or your client like to be heard? And Mr. Rogers, would you like to add anything today?
No.
Okay. The court is going to find that reinstatement is not warranted. The court also finds that prison is unavailable. Therefore, it is the order of the court that the defendant's probation is terminated unsuccessfully. I'll order that all outstanding fines and fees be reduced to a criminal restitution order and entered into the tax intercept program. Mr. Deck, I'll ask that probation submit a proposed order for my signature as to the outstanding financial obligations. And Madam Clerk, if you'll just note that I will sign that upon receipt. Okay. Mr. Rogers, you have the right to petition for post-conviction relief from my orders today, terminating your probation, and have a lawyer represent you. If you cannot afford a lawyer, one would be appointed to you. If you cannot afford copies of the necessary records and transcripts, they would also be provided to you at no cost. If you want to petition for post-conviction relief, you need to do so within 90 days of today's date, or you lose the right to seek that review. Even though this is a termination, I'm still going to need you to sign for your review rights. We'll also need to get a fingerprint for the final termination paperwork. Ms. Ormond, anything further on Mr. Rogers' matter? Mr. Beckwith, anything else?
No, Your Honor.
Sir, we'll need you to come up. Mark will assist you with getting the signatures we need and fingerprints. What? Just the way, I know it's going to be a really simple minute entry that just says he's terminated, unsuccessful. Make a note that probation is going to submit a proposed order for the fines and fees. I don't know what else you guys do, but it's like, it's a strange thing. It only happens on Prop 200 cases. Normally with felony, you either go to prison or probation. But with Prop 200, it's probation or unsuccessful termination. It happens often. Not very often. Yeah.
Yeah.
Okay.
Pretty sure that says 74 degrees. It is.
And Ms. Ormond will probably do Ms. Blanchett Lacey next, and then Mr. Smith as soon as we're done with our paperwork. Ms. Blanchett Lacey, if you'd like to make your way up to the table, please. Oh, did you get a fingerprint, Mark? Yes. Okay, good. Thanks. You guys are fast. Okay. You'd go next? Yes. Next matter is State versus Blanchett Lacey, CR 2023-538. I'll note, you're Miss Blanchett Lacey, ma'am?
Yes, sir, I am.
The defendant is present here in the courtroom. Ms. Ormond, her attorney, is appearing remotely, and Mr. Beckwith is here from the county attorney's office. Ms. Ormond, I think I'd continue this from December 15th. You had not received disclosure or a plea from Mr. Van Auker or disclosure from the Office of Indigent Legal Services. Can you give me an update on where we stand today?
Yes.
And Mr. Beckwith, do you have the plea expiration date in your file just so I can make sure
It's
set date?
Mr. Van Auker. He put again next status hearing.
Okay, so it'll expire whatever status hearing I set.
Yep.
And Mr. Beckwith, 3 days, 8 jurors on the trial.
Correct. 2 days.
Okay. Ms. Ormond, 2 days, 8 jurors. Does that sound correct for jury trial? Okay, and Ms. Ormond, I've been setting cases out into April. Let me just take a look at my calendar here. Either April 1st or April 15th or potentially April 21st. Which do you prefer? Or 22nd, excuse me. Okay, and Mr. Beckwith, do you know right off if Mr. Van Auker has any scheduling issues with the 22nd?
No, Your Honor.
Madam Clerk, I'll set this for jury trial April 22nd. And ma'am, I'm going to set 3 different dates that you'll need to be concerned with. And then I'll set a 4th date for the lawyers. But your trial date is going to be April 22nd here in Payson. We'll begin jury selection at 9. I'll meet with the attorneys at 9:30. Okay. I'll note that that will be a county-wide jury if necessary. I'll set a final pre-trial date. Let me just find what that's going to be. I'll go ahead and utilize March 30th for the final pre-trial dates. I think Ms. Ormond already has some other matters there. That will be on my Payson calendar. I will set that at 2:30 in the afternoon. Ms. Ormond, I'm looking at March 2nd for a status hearing, which would be become the plea deadline. Will that work for you? So, Madam Clerk, March 2nd at 2:30 in the afternoon. That will be the status. And then finally, I'll set a trial readiness notice hearing on March 24th at 1:30 that can be vacated as long as the appropriate notices have been filed. So, ma'am, the 3 dates I've set for you that are relevant are March 2nd, March 30th, and April 22nd. If you fail to appear for any of those dates, a warrant could issue for your arrest. New charges of failure to appear could be filed. If you fail to appear for the trial could go forward in your absence. Do you understand that?
Yes, sir.
Okay, please continue to stay in touch with Ms. Ormond. It sounds like there still is an option for this matter to resolve without a trial, but that'll be wholly up to you after you speak with her and discuss that.
Understood.
We can, if you choose to do that, we can do that in March, or if you'd like an earlier date after discussing with Ms. Ormond, we can accelerate that date as well. Ms. Ormond, anything else on Ms. Blanchett Lacey? Okay, and that's you're apologizing for not being here in person today, Ms. Ormond? Okay. Okay, so, and Mr. Beckwith, anything else on Ms. Blanchett Lacey?
No, Your Honor.
Have a good rest of your day, ma'am. We're all done.
Thank you.
And Mr. Smith, if you'd like to make your way up. Next matter is State versus Smith, CR 2023-171. I'll note Mr. Smith is present out of custody. Good afternoon, sir. Ms. Ormond, his attorney, is appearing remotely. Mr. Beckwith is here from the county attorney's office. We're here for a status hearing. This matter is currently set for jury trial in February, and then a possible Donald advisement, as today is the plea deadline. Ms. Ormond, can you give me an update from your client's perspective? And if you reached out, is this Mr. Alcorn's matter, Mr. Beckwith?
Yes.
And did you reach out to Mr. Alcorn to check on the status of discovery at all? Okay. And Mr. Beckwith, do you have notes whether it was provided to Office of Indigent Legal Services at some point, or?
It was provided at one point. It looks like some time ago.
Okay. Because it looks like, although the case is a 2023 case, arraignment wasn't until September of last year. Okay. Mr. Beckwith, do you have the ability to extend the plea offer for a couple of weeks if I move this out to the 20th so that Ms. Ormond can reach out and try to figure out where the discovery is?
Yes, I can do that.
Okay, and Ms. Ormond, would you like me to continue this out to the 20th so that you can reach out to either Ms. Mikeworth in the Office of Indigent Legal Services office or Mr. Alcorn to try to get discovery? Okay. So, Mr. Smith, unfortunately, we're not going to be able to do anything today. I'm going to continue this out to January 20th at 3:15. That'll be your next court date. Do you have Ms. Ormond's contact information?
I do.
Okay. And then, Ms. Ormond, I'll plan on doing, if your client chooses not to take the plea, then we'll plan on conducting a Donald advisement at that time. And then we'll affirm the trial. If there is a resolution, then we can address that at that point. Okay. Ms. Ormond, anything further on Mr. Smith's matter today? Mr. Beckwith, anything else?
What time on January 20th?
3:15.
Thank you.
Okay, I'll see you back on that date, sir.
Your Honor.
Yes.
I was under the impression that today was the deadline for discovery to be offered on this matter. So you're saying that there is discovery that was provided and she just doesn't have that information?
You've heard the same thing I do. The idea with discovery is that it takes place outside of court. The only time I, as the judge, get involved is if one of the parties files a motion with me to require discovery. But I don't know where there was a breakdown. It sounds like clearly there was, because arraignment was back in September. And so I think normally the prosecutor's office will provide it to the Office of Indigent Legal Services that's then available, but I don't know that, and I don't need to get into that because that's not my purview. The parties work on that, and if either one of them is dissatisfied with what's happening in the background, they file a formal motion with me. So,
okay, thank you.
Okay, that'll be all today, sir. Thank you. Okay, and then let's see here. Okay, Taylor, Zernowski. Okay, we're going to take a 10-minute recess. We're running a little bit behind, but the clerks and I have been on the bench since 1:30, so we'll come back at 3:15. At that point, we'll take up Mr. Taylor's matter, Mr. Young's matter, and we'll see where we're at that point. So I'll see everyone back in 10 minutes.
All right.
So I just sent a message to Ryan and Candace and that one. I'm not putting my court notes anymore because Brad brings the court notes and it gets all bent out of shape.
next matter is State versus Young, CR 2025-454. I'll note Mr. Young is present along with his attorney, Mr. Bednar, and we have Mr. Beckwith from the county attorney's office. We're here for a trial setting possible change of plea. Mr. Bednar, can you give me an update from your client's perspective?
Yes, Judge. I thought that we were going to get a plea offer from the last time I was here. No plea offer was made. I contacted the county attorney's office when I walked in, and they said that they would not proffer a plea agreement until I filed a 15.2. I was unaware of that requirement by their office, Judge. I'm still awaiting some discovery from their office from a discovery request I made back at the beginning of this case. But I can file a 15.2 right away, and perhaps we could set this or reset this, Judge, for the same hearing that it was set for today. Okay. That way I could get the plea agreement, review it with Mr. Young, and then he could make a decision on how he'd like to proceed.
Okay. Mr. Beckwith, anything you'd like to add on behalf of Mr. Alcorn today?
No, Your Honor.
Mr. Bednar, I'm going to, normally we go ahead and get, if they're not resolved today, we get them on the trial calendar, but given what you told me, I will reset this out 4 weeks if you'd like to. Are you available February 2nd at 2:15 in the afternoon?
Judge, actually I start a 2-week trial up in Coconino County,
okay,
and it goes in Superior Court until, let me just pull it up real quick.
Do they go on Mondays?
They go on the trial?
Yeah.
I just want to check my calendar real
okay,
quick
please do.
to see if that's going to be the case. So, no, Judge, it looks like we're going to go from Tuesday to Friday that week. So I would have...
The second will work for you?
Yeah. Would you allow me, Judge, to appear via Zoom since I'll be in trial up there reviewing some issues with witnesses, I'm sure, the day before?
Yes, that's fine.
Thank you.
Your client will need to be here in person, but...
Understood. Okay. Thank you, Judge. I appreciate that.
Okay, so Madam Clerk, I'm going to reset this for a continued trial setting, possible change of plea. Time will be deemed excluded between now and then. February 2nd at 2:15 in the afternoon. If you'll note, Mr. Bednar may appear remotely, but his client will need to be here in person. And again, Mr. Bednar, if it's not resolved on that date, I'll go ahead and get it on my trial calendar. Typically what I'll do is I'll set a trial about 16 days before a pretrial conference, and then somewhere in the middle between there and when we're setting it a status hearing to go from there.
And Judge, do you know, as far as your calendar goes, if we were to set it on February 2nd, how far out you're going?
Today I've been setting trials in most of them in April.
In April?
Yes.
Okay.
So a ways out, but maybe not quite as far as some other counties.
Thank you.
Okay. Mr. Beckwith, anything else today?
No, Your Honor.
So, Mr. Young, I'll see you back in person, though, February 2nd. If you fail to appear, a warrant can issue for your arrest. Make sure you're here. Continue to stay in touch with Mr. Bednar, so as he gets that information, he can pass it on to you promptly. Okay, that'll be all today.
Judge. I appreciate that.
And Mr. Taylor, if you want to make your way forward. Or is it Mrs. Taylor? I apologize.
Prosecutor that's assigned to this case.
Taylor. Okay, just have a seat right there. Mr.
You're welcome.
Ormond, are you back with us? And you're on mute, Ms. Ormond, so we can't hear you. Okay. Next matter will be State versus Taylor, CR 2025-378. I'll note that Ms. Taylor is present out of custody. We're set for a pretrial conference today. There is a trial currently set for January 21st. I'll note that Mr. Beckwith is here from the county attorney's office. I don't think I mentioned his name. Counsel, I'll let you know that as of right now, the Beckwith matter, I'm sorry, not the Beckwith, Mr. Beckwith is here. The Vickers matter, which is Mr. Alcorn and Mr. DeBrigida, which has priority in this matter, is moving forward. And I see in this matter, both counsel have filed notices that they will not be ready for trial. Ms. Ormond, let me start with you. As far as what I set next, would you suggest that I reset this for a trial setting conference or just go ahead and find a new date for us? Okay. And Mr. Beckwith, Mr. Beckwith, on behalf of Mr. Van Auker, any objection to that?
No, Your Honor.
And so, Ms. Ormond, if I did that, looking out to February 2nd in 4 weeks, would that work for you? Yes. Okay. Okay. So, Madam Clerk, I'm going to set this. I'm going to vacate our trial. It's currently set for January 21st. I'll note that it's being vacated as the court's calendar congestion does not allow me to do that trial on that date, as I already have an older case that has summonses out. I'm going to set a trial setting conference for February 2nd. That will be at 3 o'clock in the afternoon. So, Ms. Taylor, that's the next time I'll see you. Do you still have Ms. Ormond's one of her business cards so you can contact her? You need to make sure that you circle back to her so that she can assist you in this matter as it moves forward.
Okay.
Ms. Ormond, anything further on Ms. Taylor's matter today? Okay. Sure, go ahead. I think as far as I'll leave that to the parties. I've tried to make it so that each party could do it on their own, but if you want to avoid the paper and file a stipulated motion, I think that's fine. Okay, so ma'am, I'll see you on that date. Make sure you circle back to Ms. Ormond so she can assist you. Thank you, ma'am.
Thank you.
Okay, Ms. Ormond, I haven't seen Mr. Golay. Do you have any information on him? And also Bowman, do you want to take a moment? I think I can probably do one of my arraignments. Well, let me see. And Mr. Edwards, are you zooming in for court this afternoon? And I'll need you to ask you to take off your hat since you're appearing virtually. You're still in court. What type of hearings do you have today, Mr. Edwards? Okay, and I'm looking. I don't show you on my calendar, Mr. Edwards. Do you have a case number for me?
I don't think he's supposed to be here.
Oh, so Mr. Edwards, you're not the defendant. You're a victim? Okay. Thank you. Okay. Ms. Ormond, what I'm going to do, if you want to take a moment, reach out to Mr. Golay or Mr. Bowman. Mr. McCarty, we have Mr. Sarnowski here. We'll do that matter next. Mr. Sarnowski, if you want to come on up to the table. And then Mr. Edwards, I think the arraignments are set at 3:30, so if you just want to hang with us for a few minutes.
Taylor, maybe you can see everything that she's doing there.
Okay.
Someone in our office said they can see everything you're doing there. It's on live stream.
Okay, next matter is State versus Sarnowski, CR 2025-562. And sir, you're Tamarin Eric Sarnowski?
Yes.
Okay. I'll note Mr. Sarnowski is here. Mr. Beckwith from the County Attorney's Office is present, and we have Mr. McCarty, one of the court-appointed attorneys, appearing remotely. Mr. Sarnowski, this is the date and time set for arraignment on a Gila County and grand jury indictment that was returned on December 9th. You have the right to remain silent. You also have the right to be represented by an attorney. I see that you filled out a financial affidavit. Let me just take a look here. Okay, and you've mentioned Ms. Vork's name. Have you retained Ms. Vork for this matter?
I have spoke with her.
Okay, do you intend to hire her, or what's your status?
If need be, yes. Yes, that is.
Well, this is a felony, sir. So a class 4 felony, you could get up to 4 years probation, 1 year jail, up to 3.75 years in prison, and a $150,000 fine. So most folks choose to either hire an attorney if they're able. If they're unable to hire an attorney, then they ask for a court-appointed attorney. Okay. Would you like me to continue this matter several weeks so you can speak further with Ms. Vork about this matter?
Miss Vork will be representing me.
Okay. And so if I set this out to January 20th, because Ms. Vork is going to need to be here. She's going to need to formally file a notice of appearance and go from there. So, Madam Clerk, I'm going to continue arraignment in this matter out to January 20th at 3:30 in the afternoon. If you can make a note in the minute entry that it's believed Ms. Vork will be filing a notice of appearance. I'll ask that the financial affidavit be filed. I'm going to go ahead. You filled out a release questionnaire. I'm going to go ahead and address that right now. At 3:30. I'm going to write on there what your next hearing is. Mr. Beckwith, Okay, I'll note for the record that there is a victim present virtually as well. And that was Ms. Martinez from the victims unit. Mr. Beckwith, the defendant was summoned. Do you have any objection if he's formally put on OR release?
No objection.
So I'll formalize your OR release, sir. So you're going to get a copy of this form, which says your next hearing, which is January 20th at 3:30 for arraignment. Circle back to Ms. Vork so she can file a notice of appearance. She'll either be virtual or in person at that date, and we'll go forward from there. Okay. As soon as you get a copy of this, you'll be all done today. Mark will get you a copy after it's filed in. Okay. And then, Mr. Edwards, as we go through these matters, if you have questions, I would suggest that you reach out to the victims unit from the county attorney's office, and they can advise you of what your rights are in these cases. And we'll need the jail on virtual because we'll need them on Jocelyn.
I believe Cody Bowman is currently in the Department of Corrections.
I don't think we have him on today. We do have
Corey's already.
Oh, 3 o'clock? Oh, he's at 3 o'clock? He's now in DOC?
He might be a little close, because it looks like he's on with Graham.
Okay. Yeah, that would be helpful if we knew where it's at. And then this is Mr. Grazioli. Okay, let's see here. Mr. Beckwith, who's assigned to the Sarnowski matter?
Sorry, let me check. It's Mr. Elkhorn.
So it actually looks like Graham County probation arrested him.
So he may be in Graham. So is he? Do you think look like he's in Graham County then?
I believe he should be in Graham County.
Okay. Okay.
That was as of last month, middle of last month
That was as of December?
that he was in there. It doesn't look like he posted bond or anything, but as I can only see what probation's inputting, so.
Okay. I can probably. I think I could look in there. I think I have access to their case management software. Is that Mr. Grazioli? Okay, good. That's fine. Okay. Okay. Let's see. Is Mr. Grazioli here? If you want to come on up to the table there, sir. Okay. Next matter will be State versus Grazioli, CR 2025-558. And sir, are you Robert Paul Grazioli Jr.?
Yeah.
Okay.
Yes, sir.
Mr. Grazioli, this is the date and time set for arraignment on a Gila County grand jury indictment that was returned on December 9th. You have the right to remain silent. You also have the right to be represented by an attorney. I've been informed by my bailiff that it's your intent to hire counsel on this matter.
Yeah, I'm gonna be retaining Evan Lloyd.
Okay. And so I can continue this matter if you'd like 2 weeks so that Mr. Lloyd can be present for arraignment. Or would you like me to do that?
Yeah, that's what he advised or asked me to do, is ask for continuance until he can get down here.
Okay. So, Madam Clerk, I'm going to continue arraignment in this matter to January 20th. It'll be 2 weeks from Tuesday, since Monday is a holiday. That will be at 3:30 in the afternoon again. If you could note, Madam Clerk, that Mr. Grazioli intends to retain Mr. Evan Lloyd in this matter. And Mr. Beckwith, I'm going to go ahead and set release conditions today. Do you have any objection if the defendant remains out on his own recognizance?
No objection.
So you'll be remaining out on your own recognizance with the standard release conditions that are on this form, sir. Okay, so in Mr. Beckwith, is this a matter? No, there's no victims on this matter. Am I correct? This is a different matter, or is this?
Let me look at the indictment.
Okay. That were with us.
It is a victim matter.
But we don't have anyone online?
No.
Okay.
No, oh, not with us, no.
Okay. So, Mr. Grazioli, as soon as you get a copy of this form, you'll be done today. I would advise you probably get a copy of this also to Mr. Lloyd's office right away, so they'll have that. Okay. That'll be all then. As soon as Mark gets you a copy of that, you're done today, sir.
Thanks, Your Honor.
You're going to just throw away the extras, right? Oh. Okay. Do I have Mr. Joslin at the jail with us?
Yes, sir.
Okay, just a moment, sir. Let me pull up your file, and we're going to do that one next. And Mr. McCarty, I believe we will need your assistance on this matter. Okay. Next matter is State versus Jocelyn, CR 2025-525. I'll note that Mr. Jocelyn is appearing remotely from the Gila County Jail. Mr. Beckwith is here from the County Attorney's Office. Mr. DeBrigida was appointed at his initial appearance. Mr. Jocelyn, given our scheduling today, we don't have Mr. DeBrigida with us, but I'm going to ask Mr. McCarty, one of our other court-appointed attorneys, to stand in for arraignment today. Mr. Joslin, I'm sure at your initial appearance you were advised formally of what the charges are, but let me just echo it. Count 1 alleges aggravated assault with a deadly weapon, a dangerous nature offense, a Class 3 felony from November 29th of 2018, related to a fixed blade knife with the victim alleged to be a Mr. Hunter. Mr. McCarty, with that summary, are you willing to waive a full formal reading? So, Mr. Joslin, I'm going to enter your not guilty plea of record, a denial as to any sentence-enhancing allegations. Mr. Joslin, did you get a business card for Mr. DeBrigida when you were first had your initial appearance?
Yes, sir.
Okay. So, I'm going to set a trial setting possible change of plea for you. That's going to be on, let's see what date we're using here. I'm going to set that on February 9th. Madam Clerk, I'll set that at 10:30 in the morning. That will be on my Globe calendar with a in-person appearance by the defendant. Mr. Joslin, because this is a victim matter, I do not have the ability to review your release conditions today. You'll need to reach out to Mr. DeBrigida and talk to him. If he believes that it's appropriate to review those, he'll need to file a written motion. The state will respond after victim input, and then I will review that. I will note for the record, and I'll thank probation for getting a public safety assessment filed. So again, Mr. Joslin, you'll need to reach out to Mr. DeBrigida so he can begin working on your representation. Anything you say can be used against you, so if it's related to the charges, I'm sure Mr. DeBrigida would advise you not to say anything. Okay, go ahead, sir. Okay, and sir, I just told you I cannot legally I cannot address your release conditions today because The victims have not been notified, so probably the best thing you can do, if you have any information on that, reach out to Mr. DeBrigida. He can then file a written motion, and I'll consider that after the state and the victim have had a chance to weigh in. Okay? Yes. Let's see here. It looks like 1,000 cash or surety are your current release conditions. If you post that bond, you'll need to make sure you're in Globe March 9th at 10:30. March 9th, I believe. I said, Madam Clerk.
I have February.
Oh, no, I did. February 9th. That's correct. Thank you, Mr. Jocelyn. You were listening better than I. I'm going to go ahead and set it on February 9th, which is what I said. So, okay, that'll be all today, sir. Thank you. Okay, let's see here. Let's see, Mr. Morris, come on up. Did you need to help Mark? Okay. Do you need her phone number?
Yes.
She just sent me. I have an email in my email box from her. I thought I did. Maybe I don't. I guess I don't. Gila, there we go. Gila County Personnel. 928-402-8679. Teresa Myquirth? Yep. Next matter is State versus Morris, CR 2025-561. And sir, you're Seth Arlen Morris?
Yes, sir.
Okay, and can I have you scoot forward a little bit just so we can get your voice recorded? And Mr. Morris, this is the date and time set for arraignment on a Gila County grand jury indictment dated December 9th. You have the right to remain silent. You also have the right to be represented by an attorney. I'll note Mr. Beckwith is here from the county attorney's office. There is a victim appearing remotely. Mr. McCarty from the Office of Indigent Legal Services. Mr. Morris, my bailiff has indicated to me that you plan on retaining your own attorney. Is that correct?
Yes, sir.
Okay. We're going to do a couple of things today, and then what I will do so you can retain counsel is I will continue the matter 2 weeks. That way, have you already started talking to any attorneys?
No, I've been trying to look for one. I'm actually living in Texas. I had to come down here to do all this. So.
Okay. So I'm going to continue arraignment to January 20th at 3:30 in the afternoon. That's 2 weeks from tomorrow, Tuesday. Mr. Beckwith, if I set release conditions today, do you have any objection if the defendant appears remotely at that next hearing?
No, Your Honor. No objection.
So, sir, are you planning on returning to Texas?
No, sir.
Oh, you're going to stay here until this matter?
Wait till it's all taken care of.
Okay. So I've reset today's hearing out to the 20th, which is 2 weeks from tomorrow.
Okay.
You need to be here at 3:30. Have your attorney on board by that point. He or she then will appear in person or will appear remotely.
Yes, sir.
Okay? I'm going to go ahead and set your current release conditions today, and I'm going to write down what date that is so that you'll have it written down. Okay. Mr. Beckwith, any objection to him remaining out on his own recognizance?
No objection.
I'll set your release conditions then as your own recognizance, which is what you are today. You'll need to just make sure you abide by these terms. If you're going to remain here in Arizona, that's one of the standard terms. After you talk to your attorney, if you decide you ask to go back to Texas, you'll need to get permission from the court to do so. Okay, and one of the conditions also is that you have no contact with the victim in the matter. Okay. Mr. Beckwith, anything else then on Mr. Morris today?
No, Your Honor.
Okay, sir, as soon as you get a copy of this, you'll be done today.
Okay.
You can see what you're doing.
Doing anything.
Okay, and the last matter on our arraignment calendar is State versus Schaefer. CR 2025-566. Note Mr. Beckwith is here from the County Attorney's Office. Mr. Beckwith, I had notes either from you or from the Office of Indigent Legal Services that you had not been able to achieve service on Mr. Schaefer.
Your Honor, it looks like we were able to successfully serve the defendant, and I am being asked to request a $5,000 ACIC warrant.
Okay. And did you usually? So when was he served? Let's see.
Is that? We don't have it with us, so I don't know. But the notes from Ms. Cheska state that he was successfully served.
Okay. Okay, and was that through mail or personal service, or how did that occur?
It was certified mail.
It was certified mail.
Certified mail?
Yep.
Okay. And so you're asking, I'm sorry, you said you're asking for a warrant today?
An ACIC in the amount of $5,000 cash or surety.
Okay. Okay. And was he served here in Payson or in? I'm just trying to figure out whether it's a Division 1 or a Division 2 case, because it looked like one of the charges.
It was Payson. What we have.
Okay, but is it investigated by Globe PD then? Count one.
We have Globe PD was involved.
Okay, it is
a
Division 2. Well, is it? So strange.
It looks like the defendant at least lives in Payson.
Okay, that's right, because it's a Division 1 case, but the defendant resides in Payson, I think is what was.
But yeah, Ice House picnic area.
Okay.
Looking for an address. Sorry.
So, Madam Clerk, the state has requested a warrant. The court's going to issue an ACIC warrant, $5,000 cash or surety on the bond for Mr. Schaefer, and I'll affirm the assignment to Division 1. Okay. So, Mr. McCarty, I think that's the last one we had for you this afternoon. She actually had an earlier case, and so I did her arraignment this morning. I think she had Mr. DeBrigida on another matter, so we handled that one. Thank you for checking on that. Okay.
Oh, do
and
we have?
So, Mr. Edwards, I think that's all the cases we had where you were a victim today. If you have additional questions, I'd suggest you reach out to the victims unit. I don't think I had Mr. Powers on today. Let me just see. Jesse, you said was his name? Powers. Oh, there we go. Here. I'm not showing that we have an open case on Jesse Powers. You may need to circle back to the victims unit and see if there is one. Do you show one? Looks like we have someone who's, what is it? So last name Bauer? Is it Jesse Michael Bauer-Powers? Okay, that's set on January 20th, it sounds like. Okay. Thank you. Okay.
Your Honor, do we have a Corey Bauman today?
Yeah, we have Bowman and Golay still.
Oh, okay. All right.
Okay. Ms. Ormond, are you back with us? Okay. I think what I'm going to do, Ms. Ormond, I'm going to call the Bowman matter first. Probation has provided us in the courtroom with some information, and I don't know if you came up with any information, but we'll go ahead and call it. I'll say it on the record so we don't have to say it twice. Okay. Next matter is State versus Bowman, CR 2025-485. I'll note that Ms. Ormond is appearing remotely on behalf of Mr. Bowman. Mr. Bowman is not present. Mr. Beckwith is here from the County Attorney's Office. We have Ms. Mansour from Probation. Ms. Mansour indicated that at least as of mid-December, Graham County Probation had notes that Mr. Bowman was in the Graham County Jail. So, Ms. Ormond, I don't know if you've had any contact with him since. Looks like arraignment was in November. if you have any updated information, Ms. Ormond, that you can provide. Okay. I guess what I'm inclined to do at this point, given the fact that we don't know whether that his incarceration is due to something that happened pre or post this case being charged, I don't think I can find that he's failed to appear intentionally in the legal sense of the word. I'm inclined to reset this for January 26th on my Globe calendar. And then, Ms. Ormond, if in fact he's still in custody and you'd like to have him transported, if you file a transport order, I'll sign it. Will that work for you, Ms. Ormond? Mr. Beckwith, any issue with that?
No, Your Honor. You said January 26th?
Yeah, January 26th on Globe. So, Madam Clerk, I'll set this for continued trial setting, possible change of plea, January 26th in Globe. That will be at 2:30. Okay, and we'll see where, if the defendant is out or in, and we'll go from there. I'll find that time is excluded since the defendant failed to appear, whether it's of his own volition or not. Okay, that'll be all then on Mr. Bowman. Let me go to... Thank you. Okay, and then I believe the final matter of our afternoon will be State versus Golay. Two matters, CR 2025-375 and 376. I'll note that Ms. Ormond is appearing remotely. Mr. Beckwith is here in the courtroom. The defendant is not present. Ms. Ormond, do you have any information you can provide about the defendant's whereabouts? Okay. Mr. Beckwith, is the state asking for a warrant for Mr. Golay today?
Yes, Your Honor.
Okay, and Mr. Beckwith, in the past, I think there was a $500 cash-only bond on each of those, and that held him until the court changed his release conditions to OR. Do you have a proposed bond?
I think that the same would accomplish.
And
what we're trying to do.
ACIC on the warrants?
Yes, please.
Madam Clerk, I'll order an ACIC warrant, $500 cash on each. Ms. Ormond, if your client does have contact with you, I'll note that neither of these matters are victim matters, so if there has been a misunderstanding, the court can change the release conditions upon his self-surrender to the courts. Okay, Ms. Ormond, anything else on the Mr. Golay's matters? Okay, Mr. Beckwith, anything else?
Nothing further, Your Honor.
Okay, and Madam Clerk, I think that's all we have. Okay, thank you, everyone. Have a good rest of your day.
Good job, guys.
Thank you. Get you out of here in a decent hour. Thank you. Okay.
I'll be back until we still Tina's position. So.
Okay. So are you applying for Tina's position, but you just don't have it yet?
Yes.
Okay. Okay. So Tina, does she have her caseload?
Yes. She's doing field training.
Okay. So is Scott training her, or who's training her?
I'm field safety training her, and then in office, Dan and Scott are doing that, the juvenile stuff. So.
Who does the juveniles in Payson and Book?
Angel Hook.
Okay.
She used to be pre-trial.
Angel Nosy?
Oh, Nosy, yeah. She used to be Hook back in the day. Everyone changed their last name. That's why I didn't change mine this time.
That's right. It is simpler. I understand why people do it, but at the same time.
Oh, like, that's why I didn't do it this time. But yeah, hopefully we'll have some stability after this move. And we won't be moving as much.
We still have had pretty been a pretty stable group.
Yeah, I think Globe will have like a turnover, like a bunch of turnover, and then they'll be okay, and then we'll have a bunch of turnover, and then it goes back. It's like flip flops. But
And it's tough because
Mark, do you want me to plug this back in?
if you if you don't have roots here,
yeah,
you get with federal probation or something, they'll pay you a lot more.
Oh yeah.
But you gotta leave.
Yep. And that's where, most people come up.